help a person to know the power of effective, empathetic communication and choice of words to put across one's perspective to the one with whom we look for an agreement while in dissent through self-dialogue. It is both an honor and responsibility to speak before you today on a subject that holds the power to transform not only our justice system but the very fabric of our society: mediation. Ladies and gentlemen, our theme for today's conference is Outreach of Mediation 2.0, Exploring New Pathways. So, as you all know, that mediation is a far-reaching topic and a very in-depth topic. We have two panel discussions. So, before opening up the first panel discussion, I explore the topic. The topic for the first panel discussion is Empowering Society Through Mediation, a Bar and a Bench Perspective. This topic invites us to examine how both legal professionals and judiciary can jointly lead this transformative journey. With these thoughts in mind, I now take the privilege of introducing our esteemed panelists for our first panel discussion. The first esteemed panelist is Dr. Sudhir Kumar Jain. We welcome you, sir. Sir, we request you to please join us on the dais. Ladies and gentlemen, though Sir needs no introduction, but Sir has been serving as a former judge for Delhi High Court, and currently he is the judicial member NCDRC. Sir is the pioneer of mediation. There has not been a single mediation, I take a lot of pride in announcing this, that there has not been a single mediator in this country who remains untrained through Sir's hand and through Sir's knowledge. Sir has been the one who has been promoter of this entire mediation perspective throughout. We welcome you, sir. Our second esteemed panelist is our Additional Solicitor General, Shri Chetan Sharma ji. Sir has been appointed as the Additional Solicitor General in 2020. We welcome you, sir. We request you to join us on the dais. Sir is a man of wisdom, having deep knowledge on every subject, not just pertaining to law, but life. And the most great fact about Sir today is that Sir has been promoting mediation in our Delhi High Court extensively, being the member of the overseeing committee of Delhi High Court Mediation Center Samadhan. May I request everyone to give a round of applause to Sir. We are delighted to have you, sir. Our third and very important dignitary here and our panelist, Veena Ali ma'am. We have the privilege amongst us of having the organizing secretary of Samadhan, Delhi High Court Mediation Center. Now we are privileged to have you. Ma'am, over the years, has built a strong foundation of promoting mediation at several levels. Ma'am has played a very important and crucial role in facilitating mediation as an alternate dispute system. Ma'am, we are delighted that you have joined us as a panelist today. Ladies and gentlemen, the fourth and one of the promising members of as a panelist, we have Mr. Rajesh Mishra, Honorary Secretary, Bar Council, Delhi. Sir, we request you to join us over the dais, please. Sir has been the youngest member ever to be elected to the Bar Council of Delhi in the year 2009. Sir has been serving the entire fraternity since then. And Sir is himself a certified mediator, having resolved various crucial disputes through mediation. The fourth panelist, we have a very powerful woman amongst us, Ms. Pragya Baghel, Honorary Secretary, Supreme Court Bar Association. It's a very important fact to quote here that ma'am is the fourth female Secretary of Supreme Court Bar Association, having won with a thumping victory. We welcome you, ma'am, and we once again congratulate you on a thumping victory. Our next panelist is Mr. Sanjeev Ahuja. So may we request you to please join us on the dais. He's the President, Missing Brigades. It's a Center for Dispute Resolution of Conflict Management. Sir has been operating it since many years now, and it's one of the best ways of resolving disputes. And now, our last and final panelist, Mr. Saurabh Kanwarkar. He's the founder of Panchayat Resolution System. It's a very great initiative he has introduced. He's resolving disputes at the village level, at the lowest level, through alternate dispute system. We welcome you, sir. We are privileged to have you here. Before we begin our discussion, I would request Yudhvi sir to come over the stage and please felicitate Dr. Sudhir Kumar Jain by way of presenting a platter to sir. May I request everyone to please join hands. Now may I request Mr. Rajesh Kumar Batra, Senior Founding Member and Coordinator, EMW Assam, to come over the stage and felicitate Mr. Chetan Sharma, our learned Additional Solicitor General. I now request Ms. Romila Acharya, Senior Founding Member and Coordinator, Team EMW, to come over stage and felicitate Ms. Veena Rally Ma'am, our Organizing Secretary, Delhi High Court Mediation Center. I now request Ms. Devjani Mitra, Senior Founding Member and Coordinator, EMW West Bengal, to please come over the dais and felicitate Mr. Rajesh Mishra, our Honorary Secretary. I now request Mr. Sachin Jain, Senior Founding Member and Coordinator, EMW Team Chandigarh, to come over the dais and felicitate Ms. Pragya Baghel, our Honorary Secretary, Supreme Court Bar Association. I now request Ms. Hari Krishna Namaseva, Senior Founding Member and Coordinator, Team EMW, Andhra Pradesh, to come and felicitate Mr. Sanjeev Ahuja, our President, Missing Bridge. I now request Lata Prasad, Senior Founding Member and Coordinator, Team EMW, Team Karnataka, to come over the dais and felicitate Mr. Saurabh Kanwarkar, Founder, Panchayat Resolution Center. Ladies and gentlemen, Dr. Sudhir Kumar Jain is the chairperson of the first panel. So with your due permission, may we begin the discussion?
Excuse me, ये लाइव चल रहा है, थोड़ा आप साइड हो.
So my first question of the panel discussion is for our chairperson, Dr. Sudhir Kumar Jain. So my question to you is, do you believe that public trust in mediation can be built without the court's direct involvement? And if so, how can the judiciary help facilitate the transition?
Thank you. First, I would like to extend my thanks and deepest gratitude to Team EMW and the organizer of this function for giving me this wonderful opportunity to be the part of this wonderful gathering of mediators and those who are concerned with the mediation in this country and abroad also. You asked a very good question. It has, what in my humble opinion, it has two parts. Whether the public trust in the mediation can be generated without the direct involvement of the court, and how the court can help in this transition from the role of the court directly to the public. First, I will take up the second part of the question. You know, before amendment in the Code of Civil Procedure 1908, before incorporation of Section 89, which was repealed when Arbitration Act 1940 was enacted, the word mediation was not used anywhere in any Indian statute. For the first time, the word mediation was used as one of the dispute resolution mechanisms in Section 89.
वहाँ से
Thereafter, the constitutional validity of the Section 89 was challenged before the Supreme Court in very famous case, New Salem Advocate Bar Association, Tamil Nadu versus Union of India, which was decided in the year 2002, first by the Honorable Mr. Justice B.N. Kripal, and second case in the year 2005 by Honorable Mr. Justice Y.K. Sabharwal. In that case, the constitutional validity of the Section 89 was upheld by the Supreme Court. So by this enactment or by this judgment, the Section 89, which was introduced by the Parliament, it was upheld and constitutionally upheld by the Supreme Court. Thereafter, in the subsequent judgment, very famous judgment in the year 2010, delivered by Justice R.V. Ravindran, Honorable Mr. Justice R.V. Ravindran, in AFCON case, many issues regarding the mediation they were clarified. Once the court adopted the mediation, court started the mediation, in the court referred mediation or court annexed mediation, it generated the confidence of the public in the institution of the mediation. Section 89 was given liberal interpretation. Various facets and issues directly or indirectly connected with the mediation, the institution of the mediation, they have been clarified the Supreme Court in various judgments. Now, the courts, whether it's a district court, high court or the Supreme Court, they have started to refer more and more cases for mediation, and large number of cases have been settled by the process of mediation. I remained in charge in the Delhi Mediation Center at District Court for a number of years, and I can say with my own information and knowledge, about 3 lakh cases have been settled by the process of mediation. In High Court, I was a member of the High Court Mediation Committee, Samadhan, Madam Veena Reddy, organizing secretary is sitting with us. More than 25 cases have been settled by the process of mediation, right? Right. So large number of settlement of the cases, the pending cases by the process of mediation, it reflects the confidence, the trust of the general public, the general litigants in the process of mediation. And this is, I am telling the situation, the current situation in Delhi, and what about the rest part of the country. Everywhere the cases are being referred by the court and they have been settled by way of mediation. So courts at the initial stage, since the incorporation of Section 89 in the year 2002 with effect from 1st of July 2002, the public trust and confidence is gradually is building and rather built. It has been built in the process of mediation. The litigants of this country, they have started to resolve their dispute not by the process of litigation or adjudication, but by the process of mediation. When I was in the district judge, in the district judiciary, when I was in the high court, many advocates and the litigants, they used to say before I start hearing, sir, kindly refer our case for mediation. We would like to settle our case without any trial. So it means the court has played the very vital and very important role in building trust and confidence of a common man. I'm not saying the big litigant, but a common litigant. A person, a litigant who is coming from the rural background in the process of mediation. And in the district court, when I was there in charge of mediation center, I have seen the people belonging to the lower strata of the society, they started to demand or to make it clear, sir, kindly refer our case. Particularly in the petty matters, the dispute between husband and wife, family dispute, father and son, commercial dispute, business dispute, recovery matter, whatever may be the nature of the dispute, the litigants they came forward. It is because of the confidence and public trust developed and created and established and promoted and propagated by our adjudication system in the process of mediation. The court has played their role. The court has developed the court referred mediation and court annexed mediation. But if you want to grow the mediation at institutional level and if we want to take mediation up to the lower ground, then we need to come out from the court system also. Now this is the high time where we can go for private mediation. For that our parliament has enacted Mediation Act 2023, although most of the provisions have not been notified, the Mediation Council of India is not established, but with the passage of time it will be done, I hope, very shortly also. So Mediation Act 2023 and other enactments like Commercial Court Acts, Consumer Protection Act, Companies Act and many other which have started to talk about the mediation. And I also can say the various public undertaking or public sector undertaking, they have also started to use or they are contemplating and to use the mediation for settlement of dispute. Recently, I received a message from the Ministry of Telecommunication because they want to settle a high-level committee for resolution of dispute by the process of mediation without going into the litigation. And they requested me to become the chairperson of that committee, and I readily agreed to their request also. So now, with this role by this parliament activism, by other enactment, with awareness, now the mediation is starting to come out from the court system to the judicial. Now, how to develop the public trust in the process of mediation, in my humble submission, one thing is that unless and until we are able to convey to the public that the settlement by the process of mediation is much better than the outcome of litigation, it will help to generate a bigger confidence, a true confidence in the system of mediation. Now, many of you are working on this direction, and unless mediation is nothing, it is only the game of trust building between the mediator and the parties. So, for that, if you want to develop trust, we need to prepare good mediators, well-trained mediators, well-educated mediators, well-informed mediators. Once we are able to prepare a good pool or panel of mediators across the country, the public trust will be generated. Then we also need to develop the private mediation center with minimum requisite infrastructure. One of the benefits which I always visualize that the mediation settlement of the cases by the process of mediation by the court system has generated enough public trust and confidence among the general public, among the common litigants, that mediation is working in this country. They started to believe in the institution of mediation. They started to believe that mediation can be a very easiest, common, and very pragmatic and practical way to address their disputes without going to the court. So they can be taken away from the hostility of the court adversarial system to the collaborative approach of the mediation process. So they can be moved away from negativity of the court system to the productivity of the mediation process. So gradually, we are developing the public trust in the process of the mediation, in the institution of the mediation, even without the involvement of the court. Court system has already played its vital role. Nothing much can be expected now, only to refer more and more cases for the mediation. But institution of mediation has already been established, developed, and gradually public trust is building. But it can be developed without the direct involvement of the court. All of us here present in this room, we have to shoulder a very important, vital and greater responsibility to develop and create public interest in the process of mediation. Most of you are practicing in the court. As and when a litigant is approaching to you, your first endeavor should be to address the debt dispute by the process of mediation. Guide your client, guide your litigant. Let's try resolution. Let's first mediate, not litigant. When you are able to produce good results qualitatively and quantitatively by the process of mediation, definitely the days are not very far away from today, maybe a year or 2 years or even maybe less than, the public would start to believe, develop it, trust, rapport with the process of mediation. So all of us, we are having very honest duty. So I said, first we need to understand the role of the court, and then we need to understand the the building of trust without the direct involvement of the court. And even I was present in National Judicial Academy in one program organized by the High Court judges on the commercial court act. I said, being the superior judiciary, we need to develop a mediation-friendly adjudication or litigation in our society. The courts are required to give mediation-friendly judgment, not to oppose the judgment. Our endeavor of our superior court is to enforce the settlement recorded either by the court and its mediation or by the private mediation. As and when a mediation settlement is placed before the court for enforcement or for execution recorded by the private mediation or by the court-referred mediation, our endeavor should be for the execution of the terms and conditions of the settlement. If the public understands that the settlement recorded in the mediation can be very well executed with minimum intervention of the court, definitely it will be a big help in generation of the public trust and confidence in the institution of the mediation. We have crossed the initial hurdles. We have started establishing mediation at institutional level in every part of the country, particularly in the metropolitan cities. Now, it's a duty of us, those who are directly or indirectly connected with the institution of the mediation, to develop public trust without the direct involvement of the court. Public trust can be developed, may be developed, will be developed, and it is required to be developed among the litigants. So we should not, in every program in which I am dealing with the judicial officer or judicial fraternity, even the High Court judges, I used to say to them, convey to them with folded hands, that honor the mediation settlement, respect the mediation settlement. Just in the last, I will say, in the last month, I was also in a National Judicial Academy in one program on mediation for district judges. So one district judge from another state, he said, if the settlement is not appealing to my conscience, to my reasons, I can reject the settlement, I can modify the settlement. I said, no, sir. First, we need to respect and honor the right of self-determination of the parties. First, we need to honor and execute the terms and conditions of the settlement as agreed upon by the party. There is minimum chance, minimum role of the court to intervene in the terms and conditions of the settlement or to judge the settlement by their own standard. So time has come, the suitable time has come, appropriate time has come to develop a bigger public trust among the litigants, among the citizens of this country in the process of mediation without the intervention. I am saying without the direct intervention of the court. We cannot rule out indirect intervention of the court when it comes to the execution of the court. Even the commercial court act, right, the settlement can be executed like the award of the arbitration. That mediation in 2003 also mandated the terms and conditions of the mediation settlement can be executed by the decree of the civil court. And something more, I also mentioned to the judges, mediation in 2023, although not notified, it provides certain ground on the basis of which the mediation settlement even recorded by the private mediation can be challenged. I said, what we need to use at minimum level this provision of mediation in 2023. We should not resort to discard the mediation settlement we are asking of the party. So, dear friends, I can say in the last, public trust in the institution of the mediation can be developed, required to be developed and created without the intervention of the court. Otherwise, after some time, we will be lacking in proper and strong implementation of the mediation. Like in the case of arbitration, arbitration belongs to India, but arbitration seat in the Singapore and arbitrator is coming from the Hong Kong. So that time needs to be avoided. We need to develop. Dispute belong to this country. Mediation center is situated in this country, and the proposed mediator should belong and should come from this country. So at the last, we should take this responsibility to develop public trust and confidence in the institution of mediation without the direct or intervention of the court. Court has already played their vital role in establishing the mediation and generation of public trust in the mediation. Thank you very much for this. Thank you.
Now my next question is for our learned Additional Solicitor General Chetan Sharma ji. Sir, my question to you is, how can educational institutions, workplaces, government bodies be brought into fold of mediation awareness and training? Do you think it is also imperative for such institutions and setups to run regular sensitization workshops on interpersonal soft skills, communication, so to handle differences, discords in one's life?
Very good morning to all of you. Before I answer the question, can I just make a small prefatory introductory diversion? There are many of some regions who are here, and firstly I must congratulate you all for this marvelous E-M-W, to pushman, to middleman, your energy, your vibrance, your trust, your propulsion has made this mediation a huge success. I can see from the gathering. Let me tell you, not 1/10 of you all gather at 10 o'clock in any function. So the first thing I asked, तुम्हारे लोग कितने होंगे? क्योंकि लंच तो 1:30 बजे है। मैंने कहा सर आप चिंता ना करें। मैंने कहा ये थोड़ी she's pitching it over. I had this impression, but when I entered and I saw a full house, so at 10 o'clock it is 10 out of 10 for all of you. I also must say that the verve and the enthusiasm that you bring to the table, and we are privileged to be amongst Nari Shakti, and I can see a whole lot of our respected Nari Shakti here. So I firstly bow before you all. I acknowledge your presence, because ultimately हमारी जो मीमांसा है, हम जिस संस्कार से आते हैं, उसका सृजन जो है वो मां से। Everything is rooted in the feminine energy. This world is run by energy. It is not run by energy. और जहां इतनी एनर्जी होगी, वहां मीडिएशन तो सक्सेस होगा ही होगा। One cannot but notice amongst all of you ladies, Shri Singh, perhaps most of you don't know, he is the founder director of this very hotel. अब इन्होंने ये नहीं कहा कि ये मेरा नाम ही है इस होटल में, नाम तो नहीं कहा। One more thing, he is being feted by the House of Lords, by none other than the House of Lords, as the pioneering and pivotal legal doyen that India has. So it's a big honor to have you here. We have also in the guest list Shri He's earmarked a new niche for the profession. And when you talk of institutionalization of mediation, the first thing, and this answers your question, middleman, this answers your question as to what are the imperatives. The imperatives in today's times are that you should be seen. This is the age of social media, with its pluses, with its minuses. So everything is today a photo optic. It is information based. It is information disseminated. It is data dispersed. Everything we are on this. Even your AI in algorithm is basically a data dispersion and a data collection. So the likes of Tarun, and I dare say that we also have Madam Bhumi. She was with SCC in a very senior position, and she's coming into her own on this very line of dissemination, information, analysis of what the legal world is. Because that day, Wazir Saab, when the DG spoke, he said, law and its institutions are one of the pillars of the economy. If the investors, if the people have faith in the judiciary and its certainty of judicial decisions, the investors and the general public, they are enthused, inspired to invest. Trade booms, economy booms. So from your fourth pedestal which you have reached, which is a big thing for Bharat, to come to 3 and to break into 2 and 1 by 2047, this institution has to be strengthened. And the best way to do it, I think, is mediation. We recently had a mediation day, Rajendra. It was held under the aegis of the Ministry of Law, the Attorney General, Solicitor General, all the law officers, all the Chief Justices of India, Chief Justices of the States of India, and all the mediation committee members all over the country, High Court judges, they were there. And the push that was given was कि हम mediation को एक पार्ट बनाएं. So I'm answering your question. तो mediation को कैसे पार्ट बनाएं? Let me just tail end the first question that you put with the second, but you tell me when I'm exceeding the time, I'll stop.
Not at all, sir.
The first thing is judicial intervention required in mediation? तो मेरे जो दोस्त हैं, he's my friend also, और हम दोनों का बड़ा प्यार है, लेकिन मैं कह सकता हूँ साहब मैं आपसे डिफर देखिए, this is a talk and dissent. It should not be that dissent is pushed, but yes, I think, see, we are in a process where we are taking mediation up into institutionalizing it. The courts have been there. There is a fear of courts. There is an awe of courts. That awe makes people respect. भय बिना होए न प्रीति. ये हम लोग हैं. हम तभी पूजा करते हैं जब हमारे पे मुसीबत आती है. जब नहीं होती तो ठीक है. ये सबके साथ होता है, मेरे साथ भी है, कोई ऐसी बात नहीं. This is natural. तो जब तक बिग ब्रदर आपको नहीं देखेगा, हम लोग जो हैं भारतीय खास तौर पे, आपने इमरजेंसी में देखा था ना, अगर 10:30 बजे दफ्तर लगता था तो 10:25 पे सारे होते थे. We are a community which respects fear, and to that extent fear is important, and to that extent courts are very important. But वो सिर्फ fear हो और fear में मामले लटकते रहें या fear में आप settlement ना करें, वो भी गलत है. So let it be a hybrid. So let it be a hybrid. Let the courts oversee. Let Order 23 Rule 3 be amended to include part of Section 89. Let Order 23 Rule 3 have certain provisos where mediation can be statutorily engrafted in the CPC, just like you have in a suit. Pleadings Order 6, Order 7, Order 8, Order 9. You have issues, you have evidence. You make it collateral, parallel with that CPC in engineering and in grafting mediation as part of a parallel Order 23 Rule 3. Pani pilo, madam. See, this is a thought. This is a very, very revolutionary thought. आपको मीडिएशन आज के जी हमें मीडिएशन में भेज दो, साल 6 महीने चला बिना मैडम थैंक यू वेरी मच को कह कि हमने बड़ी मेहनत करी, थैंक यू वेरी मच, मैं नहीं मानता। अब जज साहब ने भी यही कहा कि नहीं मानते भाई, नहीं मानते। तो कई लोग पहले से होते हैं कि वी विल बाय टाइम इन मीडिएशन बट वी विल नॉट ऑनर द मीडिएशन। तो क्या फायदा फिर इसका? यू हैव अ टूथलेस टाइगर, मीरा मैन, यू हैव अ टूथलेस टाइगर। तभी मैं आपको अच्छी दंतावली देना चाहता हूं कि वो काटे भी ना लेकिन उसका डर भी रहे। सो दिस इज व्हाट आई प्रपोज, एंड बिकॉज दिस विल बी हाइब्रिड फाउंड इनटू द सीपीसी, इट विल हैव द ट्रैपिंग ऑफ अ कोर्ट, but we will have the comfort of the informal out of court within the court. You will not go out of the fear of the court, but you will not be overawed by the court proceedings per se, and you will arrive at a settlement. Now supposing during mediation, and these will be the rules and the schedules to Order 23, that amendment action. If somebody is trying to play fast and loose, if somebody is trying to play truant, then there will be a mechanism by which the court will intervene in its supervisory jurisdiction under the CPC to get that man straight on. फर्ज करो रीना मैम के सामने एक मीडिएशन चल रही है, बड़ी अच्छी। आप एक शातिर वकील को देखो, एक शातिर क्लाइंट को देखो, वो कहता है साहब मैं इसको अगर इतना डिले करूंगा तो मेरा काम बन जाएगा, देन आई डोंट बॉदर अबाउट द डिक्री। दूसरी पार्टी को जज साहब एक मिनट इधर ध्यान दो, दूसरी साइड को ये है कि साहब मुझे जल्दी है, आई नीड एन इंजंक्शन और आई नीड समथिंग इन द नेचर ऑफ एन इंजंक्शन, बट ये कहीं मीडिएशन में मेरी नाव कहीं बह ना जाए। So then what happens? Then you marry the prognosis of the court into the mediation. You institutionalize mediation, and because you institutionalize mediation within the court, you will then go to schools, to law schools, to public sector undertakings, to corporates to say कि जहां when you need to have a legal refresher course, this mediation as part of the legal process is also a mandatory course for you to do. I don't want mediation to be on the sidelines, to be a happy-go-lucky optional hobby that you pick up at your choosing. Mediation should be, Veena ma'am, an avowed thrust, institutionalized, because as we travel from the fourth economy upwards, we don't need too much of preponderance of law, appeals, second appeals, SLPs, reviews, curatives, so that determination is set at large. We don't need that. For an economy which looks to push itself up the ladder, we need determinativeness, and we need quick resolution, and we need friendly resolution. So, इस तरह से if we can look at it, I think we would have done a big job. और जहाँ तक जज साहब ने कहा कि जो छोटे लोग हैं वो तो चाहते हैं कि साहब ये हमारी सुलह को तो वो तो क्या अपना चलता रहेगा. But then I've just given you a framework which perhaps none of you have thought of.
Absolutely, sir.
This answers your question number 1 and question number 2. But before that, there's a very tall gentleman who's coming. A very tall and handsome, and he's come without a motorcycle today. Our good friend, the Chief Justice of the Madhya Pradesh High Court, Justice Sanjeev Sachdeva, a very likable, popular, and a very fair judge in every which sense. अब तो ये महाकाल की नगरी से आए. So congratulations on your assumption as the Chief Justice of the heart of India, Madhya Pradesh. I just because I think what I said was pure intellect, and because you revel in this. The question was, how far should the judicial process, immediately I am exceeding my time, should it be kept out, the judicial oversee and the judicial process for mediation, because you have been chairman of the mediation committee. अब जितनी इनकी mediation में contribution रही है, बहुत थोड़े लोगों की रही है. So sir, I was saying in a capsule, let's amend Order 23 Rule 3 to have in Order 23 Rule 3 an act which regulates mediation, which recognizes mediation. Taraman. Taraman, just to come back, I mean, whilst you were stuck up in traffic, this was all which was happening there. Amend Order 23 Rule 3 so that the fear and the overarching court process is not lost on freewheeling individuals and corporations. Side by side have schedules and rules by which you can report in case of an impasse or in case of an imbroglio within the mediation process, so that the courts are not kept out. You have the fear of the court, but the love of and the ease of mediation hybrid into one. This is what I have proposed as a thought. Yes, immediately.
So I agree with you partially. I would say it's a very laudable system, but it will probably militate against the very concept of mediation. And I've actually seen it. Though you're right, we should have judges involved in mediation, lawyers involved in mediation. The very fact that the Samadhan is so successful as compared to other mediation centers across the country is because it is lawyer run. And lawyers, I'm going to speak about that when I get the chance to speak. Lawyers play a very active role, and so do judges. I have realized I was trained as a mediator, was part of the mediation committee in the High Court, then as a judge. So my training as a mediator has helped me adjudicate matters. In Madhya Pradesh, we had a case where one of the mediation reports came to court. The mediator was a judge. He had recorded evidence of parties in mediation proceedings. They were put under oath, their statements were recorded, then he was mediated. So that if we follow this process, you're right. Something needs to be done. One thing should be like Commercial Courts Act have made pre-litigation mediation mandatory. Judges should have mandatory mediation training. Lawyers should have mandatory mediation training.
Thank you so much, sir, for your insightful words. I would now like to ask the next
That's an
question.
indication.
Because that's how बात ये होती है. Unless and until there is a free flow of thoughts, notwithstanding the time constraint. You know, this enlivens up and adds crisp and value to the proceedings.
And Menon ma'am, let me tell you, आपके scheduled time का बेशक इधर-उधर हो जाए, but you would not have had such a wonderful interactive session.
Absolutely.
Where the Chief Justice said, I want to differ with you right now.
So I now shift to my next question to our esteemed panelist, Veena Rani ma'am, our organizing secretary. Ma'am, do you foresee a parallel track system, one for adjudication and another robust one for public-private mediation mechanism running alongside?
I think I have to be very brief. So first I will say that I absolutely concur with Justice Sudhirjan and Chetanji. I concur absolutely. And having on the other side, whereas Justice Sadeva should have been there, he has been a trained mediator, our chairman, and now designate Chief Justice of Madhya Pradesh High Court. Then Justice Meena Bansal, who herself is a mediator trainer. Justice Tara, a trained mediator. I don't know about Justice Bansal, but I think we all have judges, trained mediators and trainers here. There is hardly anything to be spoken about this part, but of course, answering your question has two segments. One is the existing parallel system, and it should be robust. Nobody sitting here is trying to undermine the adjudicatory system which is in existence. But we followed this system after independence. The colonial system provided us a multi-tier adjudicatory system. Over a period of time, we realized that the society which had families, large families basically, where there were hardly any conflicts, because the elders in the house could help people to resolve their conflicts, we shifted ourselves from that social fabric to MySpace era, resulting thereto that I am in conflict with someone, but I don't find anybody to help me to come out of it. Of course, the system was overloaded because of the awareness of the public also, because for small things, people started approaching courts, and mediation was introduced as already spoken by Justice Sudhirjan. But I must tell you, today we are at a stage where the system has to be robust regarding mediation. This system has to have three competencies. Competence of the mediator, competence of the system, and competence of the mindset of the public. So far as competence of the mediator is concerned, the competence has to be also not only the process, but also the subject involved in the matter which is referred for mediation. The competence of the infrastructure is provided by the institutes. Like in Samadhan, we are completely thankful to our High Court, where every little thing is noticed and provided. In COVID, it was Justice Sadeva who encouraged us to start absolutely online mediation on 24th June 2020 itself. So in today's time, when people are located at different sites, different locations, we must have hybrid system available, complete technology available, and the staff well equipped to handle all AI related issues also. And the third one is, we should know where to take our clients as lawyers for dispute redressal mechanisms to be adopted by us. If we are not tuned in our advocacy for mediation, definitely I will show the path towards court only, and resolution becomes delayed, because then we want to follow up to the last tier of the system available. So we need to focus on the advocacy also, where, like Chetanji said, law schools, and even we should know as service providers that which matter is fit for which mechanism, whether I should take it for adjudication or should I take it for arbitration or mediation. Of course, we have traveled 20 years. People say mediation is the time, but I still have to accept this part. we have been in this journey for 20 good years. 2 years act has been passed. So we are still waiting for the enforcement of the sections. So let us join hands, do more such activities, push, and many more people sitting here, to bring us to a level where we can say, yes, we can do it. We all collectively can do it. Thank you very much.
Thank you, ma'am. Now, I ask my next question to another esteemed panelist, Mr. Rajesh Mishra, Secretary Bar Council. Sir, how can Bar Councils play a more active role in building and strengthening the culture of mediation in our country? And is there sufficient training and sensitization of lawyers on mediation advocacy techniques and ethics? What more is needed as you guide us?
Thank you, Menon. Before I express my opinion, I would like to extend my gratitude to Team EMW for inviting me and making me a part of this event. And it is a great honor for me sharing dice with my mediation guru, and of the dice, Justice Sandeep Sachdeva sir, under whom I have received my training certificate when I joined mediation training at Gurugram, I think. So really it's an honor for me sharing dice with the legends of mediation. Justice Sudhir Jain sir, I've seen him doing mediation since district court days. Justice Meena Krishna Bansal ma'am, Taraganju ma'am, and it's a really honor for me to express my opinion regarding role of Bar Council in front of Justice Sandeep Sachdeva sir, who had been a counsel of Bar Council of India since more than 20 years. Justice Sachdeva has saved us so many times, DCI Bar Council in courts. So my question was the role of Bar Council. As you all know, Bar Council Delhi is a statutory body, and people have a notion that Bar Council can command advocates. It is a wrong notion, absolutely. Nobody can on this earth command advocates. The only thing is we can request them, we can convince them. Please request your clients, go for a mediation, request them to join sessions. What I have observed as a mediator, only those mediations are successful in which advocates are cooperating with the client and cooperating with the mediators. There is one more thing which I would like to share from the stage. We have more than 180,000 advocates in Delhi, enrolled advocates. And so far as number of trained mediators are concerned, we have, I think, very limited numbers of mediators. So Bar Council of Delhi can play a role in that way. We can collaborate with the bar associations and district courts, district judges to have more sessions of mediation in district courts and in high court as well. So that we can have a more and more knowledge of mediation. Because it's an art. Mediation, like advocacy is an art, mediation is also an art. So we can have a more, being a statutory body, we can push for that. We can request the district judges as well as our advocates, association, bar association to have more sessions. Now I can come into second question. That is very important. Now time has come, since mediation has already introduced, time has come for a Bar Council of India to recommend this mediation, advocacy of mediation in their curriculum of the advocates. While our young minds are studying their LLB courses, at least not a course, if they are not able to introduce mediation as a course, at least they can have a chapter of mediation in their curriculum, so that we can train our young minds. As you all know, we have a limited resources. So by inserting a chapter of mediation as well as course in curriculum, that will help our young minds to learn mediation, the art of mediation. As it's an honor, really honor for me, whatever I am in mediation, just because of my guru, mediation guru, Veeralani ma'am, who trained me well. I don't know whether I am still doing good or not. She may certify that, but whatever I am doing and whatever I can do just because of Veeralani training. And one more thing I would like to add. Association or team like EMW, we can collaborate. The council, BCI can collaborate with EMW, Samadhan, so that we can have a more mediation training program. as I said, number of advocates are large, so it won't be possible to go for such a long session. So you can take help of Bar Council and Bar Council of India, so that we can train more advocates to have a more mediation training program, so that they should be in a position to advise their clients to have a more mediation session.
Thank you, sir. My next question is to our Dynamic Secretary, SCBA, Ms. Pratya Baghel, ma'am. Ma'am, what is your vision for the Bar Association's role in promoting out-of-court mediation in your tenure? And connecting with this is another question for ma'am, that is, what role can Bar Association play in integrating mediation into mainstream legal practice, especially for disputes that can be resolved outside the courtrooms?
Good morning, everyone. I'm happy to be part of this initiative of Team EMW. Thank you, Push ma'am and the team. I can see Nandini Gore, the senior mediator, sitting here. She was my senior and my guidance for everything she's here. So, first, what the Supreme Court, if you see, Supreme Court Bar Association doesn't per se as a mediation training program. We collaborate with Supreme Court Mediation Center for 40 hours virtual mediation training programs. So from last 4 years, I found out we don't have advanced training programs. We don't have any advanced training programs for our advocates. So what we are celebrating today is 5 years of TMT. Can anybody tell me what is TMT stands for? Push, man. 5 years as per your things, and we are celebrating 5 years of team spirit and teamwork. So in my tenure as the Secretary of Supreme Court Bar Association, I want to team up with EMW for mediation training programs for our advocates of the SCBA. So, and right now we do not have any programs till date, so we want to have independent programs with you for Team EMW. When we say teamwork, and when Sir has said about that, what we only think about is a mediator. So why not every lawyer should become a mediator to ask their client, when you are discussing and meeting the client, please do go for pre-litigation mediation. So our suggestion, we don't think mediation to become a mediator only, but to explain our client the importance of mediation, going for pre-litigation mediation, and what is the importance, how it's cost saving to us, time, it's not time consuming. So we need to train our advocates on that. So this will be one of the main achievements going to be.
Thank you so much, ma'am. My next question is to Mr. Sanjeev Ahuja. So, what policy or structural changes do you propose to institutionalize non-courtroom mediation across sectors, commercial, IT, and consumer?
Thank you. Let me start with a big thanks to Team Email to you, and both for the invite as well as for the event. I'm a chartered accountant who's not signed balance sheets. I'm a lawyer who seldom goes to the court. So, my remarks may sound a bit radical to an extent. I mean, it's not that I'm in disagreement, but of course, one statement would be, let's agree to disagree at few places. But coming back to the question, let me just pick up the important parts of the terms used in your question. So we are talking about non-courtroom mediation. We are talking about institutionalization. We are talking about structural changes and policy changes. So let me come to each of them one by one. Non-courtroom. Now we all are aware of a court annex mediation. And my request is that let's start looking at or changing the terminology to a court-directed mediation rather than just a court annex mediation. What will happen is the courts would expect the parties to try mediation in case a judge feels so. And if that be the case, let the parties get the freedom to look out the other mediation centers, which probably the double advantages. One, we'll have independent private mediation institutes and the centers which will come up. There will be a lot of support to the awareness program. And then what will happen is, at the end, mediation probably will be best successful if it reduces the inflow of such cases to the courts. Because once the parties are in court, I think a lot of voters undergone the bridge, and then that becomes like, a big task and a challenge for the judge and the court. So we all understand in the courts are in pressure, huge pressure in terms of dependency as well as infrastructure. Why not do something where mediation becomes the first port of call and people try it out before even approaching the court? Now, as an insolvency practitioner, we have used mediation techniques in insolvency practice as well. And I would say that we've been reasonably successful because on one side, IPC is a very, very prescriptive code. So the chances or the scope of mediation during the process of CRP and liquidation is very limited. But to the extent we've been able to use it, tweaking the concept, because if you really understand the concept, you can give it the right tweak and then fit it to the context. Mediation normally, whenever we have been trying to define, what we have been saying is it's time effective, it's cost effective, it's voluntary, it's confidential. Can we also redefine it and probably extend the definition by saying it includes the dialogue first, it's purely non-adversarial. This can actually help flexible and out of the box thinking and creative solution, and it definitely helps the party in parliament. So from that perspective, it's very important that we have the structural changes also, which would include pushing the right mediation process, the way we had arbitration clauses. Similarly, the right mediators, which would mean the right training programs, and then the awareness programs, and of course the mediation centers. On the policy front, I think the right set of rules, the regulations, and of course the act, which is yet to be notified, but we're all waiting for NCI to make it happen. So if that happens, there will be a lot of benefit and push to this particular concept, which is such a noble and flexible concept, which should be pushed. A statement maybe for a request for the policymakers. Let there be a place for everything and everything in its place. If we achieve this, then I'm sure potentially the bus we miss to be the arbitration hub for the world, that is something we can actually get back as a mediation hub. So let's agree to disagree wherever substance over form. Substance over form is important. Let's not be in denial. Let's learn and unlearn. Let's learn from our mistakes. If you're able to put it all together, I think mediation is going to be a golden word for a golden world. That's from my side. Thank you.
Thank you, sir. Now my last question for today's discussion is to our last and final panelist, Mr. Saurabh Karmarkar, founder Panchayat Resolution Center. Sir, my question to you is, with the judiciary already overburdened, do you see potential in court collaborations with private or community-based mediation centers to help divert appropriate cases?
Respected all the guests here. So first of all, I'm thankful to Pushman. I'm thankful to all of you, sir, for giving me this space to talk or to present the young idea that I carry, that is Panchayat Resolution Center. So I believe there might be a question if there is a discussion about mediation, why we are talking about Panchayat. Yes, we are talking about strengthening currently the existing institutions like court, the bar, the bench. We are talking about strengthening the capacity for the mediators. But let me present this model, this Panchayat, why we are talking about this community-driven. This Panchayat, this term itself is a definition for mediation now. So I believe it is India's own grassroots dispute resolution model, that is our mediation. And apart from strengthening the court or the existing institutions, if we go back to the grassroots, to the village level, to the Panchayat level, because sir, our chairperson has talked about the public trust, how the public trust will be built. This question once arises on the legal awareness camp. It was also elaborated by our panelists that we need an awareness drive in the community. And when we are talking about Panchayat system, we are not talking about the political sense of panchayati system. We are forgetting that this panchayati system itself has the judicial norms. Now, with the amendments, with the laws, we have that only thing, the political sense. So I believe that with EMW, with all the dignitaries here, with all the guests here, if we can collaborate and if we can have a pan-India movement with panchayati system to reach with mediation, that will be grateful. And again, I'm congratulating EMW for celebrating the final year, the fifth year of EMW, and that is where the term can panchayat. So I convince ma'am this term fit this panchayat, this matches ma'am. So if we can collaborate together and we will have a awareness drive in the Indian villages in coming days, and with EMW we have a lot of team members from different parts of India. If we can come together and work at the grassroots level, at the village level first, and then coming on with the district court or with the high court and supreme court, all are there. But in villages, there are no on uniform bodies. So from here, if I request all of you to collaborate for this project and work on the grassroots level, that is my final remark.
Thank you so much, sir. Now I request our chairperson, Dr. Sudhir Kumar Jain, to give the concluding remarks.
Thank you. This panel discussion was a vibrant display of different ideas on the concept and idea of the mediation. We talk about whether the public trust can be generated without the intervention of the court, and I always advocated that the time has come to develop a mediation with minimum intervention of the court. The Chetan Sharma ji has given a little bit different opinion that we need to amend certain provisions of CPC so that there can be supervision of the court. And then Madam Veena Reddy has talked about the competence of the system, competence of the infrastructure, competence of the mediator, competence of the system. Right? Without proper and appropriate competence, we cannot develop and generate the good mediation and mediation settlement, and we cannot promote and propagate the institution of mediation. Right? Mr. Mishra ji, the Secretary of the Bar Council, he very well advocated the role of Bar Council, and I really personally like the idea that the learning and teaching of the mediation be included in the advocacy training as well as in the curriculum of the different law schools coming under the Bar Council of India or State Bar Council. This is the time, high time, when we can tell, or when we can make aware about young generation about the idea of mediation. The Madam Tagyam also talked about talk about how the mediator can be developed with the help of Bar Association, and Auzadi also gave his perspective about from the viewpoint of an advocate as well as the chartered accountant. He also talked about the role of mediation in insolvency, and my young friend Mr. Karmakar is developing mediation and correlating the mediation with the system of panchayat. But at the end, it was a wonderful session, full of different thoughts, and I must congratulate and appreciate and give my big thanks to all the panelists of this session. Thank you very much.
Before we part ways with this panel, I request Manjula Venkatesh ma'am, our senior founding member and coordinator EMW Telangana, to please come upon the dais and felicitate our chairperson by way of presenting mementos, please. I now request Senior Advocate Kunal Tandon sir to please come upon the dais and felicitate our Additional Solicitor General, Shri Chetan Sharma ji. I now request Binasha Soni ma'am to please come upon the dais and felicitate our Organizing Secretary, Veena Reddy ma'am. I now request Advocate Namita Chaudhary ma'am to please come upon the dais and felicitate Mr. Rajesh Mishra, Secretary Bar Council. I now request Ms. Archana Malik, Advocate Ma'am, to please come upon the dais and felicitate Ms. Pragya Bagel, our Secretary, SCDA. I now request Mr. Siddharth Tyagi, Advocate, to come upon the dais and felicitate Mr. Sanjeev Ahuja, President, Missing Bridge. I now request Ms. Reema Kalra, Advocate Ma'am, to please come upon the dais and felicitate Mr. Saurabh Kamarkar. I extend my heartfelt gratitude and thank you to all our esteemed panelists for giving their such insightful views. We are all privileged to hear you all. Thank you so much. I request everyone to please proceed for the tea.
Everyone to settle down. Since we are running a little late, we would start off with the inaugural session. Can I request everyone to settle down, please? We are running a little late, so we will start with the inaugural session now. Honorable section now.
I request everyone to please settle down for the inaugural ceremony. I request our esteemed dignitaries and the members who joined us for this conference to please settle for the inaugural. Members of the
Can I request everyone to settle down, please? We'll be starting with the inaugural ceremony.
हाँ मैम लाइव चल रहा है
Can I request everyone to settle down, please?
Well, a kind request to everyone, please come back. We have to start our inauguration and we are already getting late. A kind request and a gentle reminder that we are still on. It's not over as yet. Please.
I request everyone to be seated, please. In next 2 minutes, please be seated. Everyone to be seated. Our honorable judges are waiting with you for the inaugural session. It is neither fair nor courteous to make them wait. All three services should be closed. Please have your seat now.
Good morning, ladies and gentlemen. To begin the inaugural ceremony, I would like to invite our honorable dignitaries on stage, please. Can I request our guest of honor, Justice Sanjeev Sachdeva, on stage, please? Justice Sanjeev Sachdeva, Acting Chief Justice, Madhya Pradesh High Court.
Excuse me, sir. Live चल रहा है
Taking the liberty to congratulate him as well.
Excuse me, sir.
Can I have the next guest of honor, Justice Meena Krishna Bansal, Judge, Delhi High Court. I request our guest of honor, Justice Tara Ganju, please. Can I request our special guest of honor, Dr. Lalit Bhasin, please? Can I now request a senior founding member of Team EMW, Mr. Thankanchan VP? Our Coordinator-in-Chief, Ms. Push Gupta. Can I request Mrs. Nagina Jain to felicitate Justice and Research Seva, please? Can I have Ms. Reema Bhandari to felicitate Justice Meena Krishna Bansal? Can I have Ms. Kamlakshi to felicitate Justice Tara Ganju? Can I have Mr. P.G. Suresh to felicitate Dr. Lalit Bhasin, please? Now that we have our dignitaries on stage, can I request everyone to rise for the national anthem, please? I would now like to invite our guests to begin the inaugural ceremony by seeking the blessings of the divine energy and join us in the auspicious ceremony of lighting of the lamps. Can I also request Justice G.P. Mittal sir to join in, Dr. Sudhir Jain sir, and Mr. Chetan Sharma sir. Can we have everyone for the lighting of the lamp, please? Veena ma'am, of course, please. Sir. ladies and gentlemen. I, Garima Sachdeva, would like to extend a warm welcome to the honorable judges, judicial officers, learned mediators, my seniors, and all those who have been here to grace this special occasion today. Welcome to the 5th anniversary of the E-Mediation Writings. Today's conference is on the outreach of mediation 2.0, exploring new pathways. EMW, as the tag suggests, is of the mediators, for the mediators, and by the mediators. With immense pleasure and delight, we take a step forward to our commitment to spread awareness about mediation by launching an online portal of E-Magazine, E-Mediation Writing, India's first digital online magazine dedicated to mediation-related information and contributions in the forms of articles, columns, and work papers, updates from all across the globe. The mediators, advocates, and litigants can share their views on the aspects and the concepts of mediations, negotiations, dispute resolution with the readers across the board. In recent times, mediation has emerged as a preferred appropriate door to resolve and to appropriate door to reform. Mediation is here to strengthen and complement judicial infrastructure as one of the most important tools for clearing the massive backlog of cases that exist. EMW is India's first organization to have a pan-India coordinators and mediators from all over the country and its branches in every part of the nation for mediation and awareness. We are glad to have been joined by our friends from all across the country today who are a part of the EMW team. The idea behind this is to create awareness of the vital role and contribution of mediation in today's peaceful times. E-Mediation Writings strives to attract and engage a wide readership including mediators, mediation trainers, lawyers, law researchers, and law students aspiring to step into the realm of mediation. Our journey started as the first online magazine with information and articles on mediation with a vision and the vision for expansion in the field of mediation. Being a COVID child, in fact, which celebrated the first anniversary during COVID, and we were honored to have been blessed by Justice Sachdeva to have graced that occasion as well. And here we are, glad to have him back on the 5th. We've been grateful to spread our wings. We've been grateful to spread our wings not just in our country but across the borders, and have members from several countries who are now a part of the team EMW. We have actively started the classroom series on mediation, where we reach students from all across the country, extending the importance of mediation. The program of 40 hours of mediation training for upscaling and updating the skills of mediators in India has been a great success for the last couple of years. We've also been glad to have launched and hosted the first Peace Awards to honor people in mediation from all across the globe. And with that idea, looking forward to expanding and taking Team EMW to greater heights and here and onwards. Can I now request Ms. Push Gupta, the Coordinator-in-Chief, to address the gathering, please.
I think it's now still a good morning and namaste to everyone. Honorable Mr. Justice Sanjeev Silvera, Honorable Mr. Justice Meena Krishna Bansal ma'am. I would pronounce Meena Bansal Krishna ma'am. Honorable Ms. Justice Taranji Gandu, our very esteemed support system, Mr. Malik Bhasin sir, a dynamic person in multiple ways. Thank you so much for being here, sir. To support the initiative of Team EMW, and I take this opportunity to thank everyone in the audience, those who have really take out their time to be with us for celebrating the 5th anniversary of our baby, which was conceived during COVID when we were all online. That was the 1st of June 2020, and here it's the 5th birthday of our Team EMW. It's a spirit of team which has brought us to this stage, and to us in team, it is defined, the acronym we take in Team EMW. Team means T is trust, E is empathy, M is we are there for each one, A is availability, and then M is for mentoring, because we have always felt, sir and ma'am, that it is not about who takes this initiative, but who embraces this initiative. We have to bring everyone in forefront to share, to care, and to join for something which our country really needs, because after the Mediation Act, it's our responsibility, which is like, as have been said in the panel discussion one, it is the right time that the Bar Council of Delhi and India make it a mandatory requisite for the advocates after 5 years of their practice to go for mediation training. That is really important, because we are going to need more mediators. Second, the quality of the advocates in mediation is something which is really bothering all of us as mediators. So with this outreach of mediation, there are a lot of things which are there in our minds, and we request your Lordship and our Ladyships to please help us create this vision in the society that mediation advocacy becomes very important in the society, in the system, because lawyers, with my complete gratitude and humility, I must say many times as mediators we have felt the major blocks are because the advocates do not know their role in mediation, which is completely different from litigation. And why we have titled this this anniversary title as Outreach of Mediation 2.0, exploring new pathways, because we have realized through mediation training and through mediation practice across the country that it has really transformed us, first as an individual, then as a professional. And I can say on my behalf that yes, it has really brought me close to the pause which I am supposed to use when I am communicating with people, where to put a break, how you can structure your words, because I truly believe that language is a keyboard of your thoughts and feelings, and it is into your hand that which key you will press. It will harmonize your relationship or it will spoil your relationship. So my dear friends, it's just a humble request that from now onwards, a duty upon us is that we should now start giving trainings to people, not just in the court corridor, but in different sectors, finance, corporate, banking. We have our panel discussion, wherein we can impart trainings upon sensitization of language of communication. Self-dialogue can prevent the conflict, can prevent discords becoming conflict. Our court system is already clogged with lot of very important cases, but majorly there are cases which can easily be resolved if two people sit together and discuss. We don't need a third person to mediate. Mediate is a mindset for which you don't need a mediator. So my request from this onward, our duty that let's take forward this vision outside the court, so that the pre-litigation which has not been made mandatory, unfortunately, by our government, we can bring that into act, into practice, wherein people ask lawyers, can we approach pre-litigation desk? Because in Delhi only, I think Delhi High Court only has pre-litigation desk. None of the district courts here in Delhi have the pre-litigation desk. It's our appeal that all over India, all district courts should also have a pre-litigation desk. It's not making it mandatory, but yes, people should know, still people have faith in the court system. Wherever we are here in India, it is only because our honorable judges, our seniors who have promoted the cause of mediation has let people have faith in the concept of mediation. And private mediation will come, but yes, we need court, we need our judges to support our cause outside also. And because of which we are coming up with some initiative, we will be requesting our Honorable Mr. Justice Sanjeev Sir and our Ladyship and Sir to launch another initiative by Team E-Mediation, which I think right now I should be holding that Garima is the right person. And secondly, my request, in just recently, few days back, on 3rd of May, we have had a national, we had Mediation Association of India conference at Bharat Mandapam, wherein our President of India, Ms. Draupadi Murmu, she made an appeal to the audience and to the country. She was very happy to receive the concept of mediation association, but she made her appeal, being a lady from a village area, tribal area, that it is right time to embrace mediation to the grassroots also. Let us empower people in villages because they cannot afford at any cost litigation because for them there are a lot of other challenges. So to go to the root, we are starting with another initiative which is called as Shahar Se Gaon Tak. This is Sulhan Setu, which will again be released, launched. We'll be requesting your lordship and our ladyships to please, we have the brochures ready with us. So with this appeal, it's a teamwork, it's a team spirit, and many milestones needs to be covered, and together all of us will take this mediation. India being the best country for mediation because it is there in our culture. We are otherwise also engaged in a way where we value relationships and connects family and everything. So I think there cannot be no other soil in the world better than India to have mediation as one of the self-dispute resolution mechanism. With this note, my thank you and appreciation and gratitude to our honorable guests and our honorable participants who are here. Thank you so much, sir, Honorable Mr. Jasu sir, for being with us for this. Mr. Chetan Sharma, Rajesh, Sudhir, Dr. Sudhir Kumar Jain, our mentor. Whatever we have learned in mediation is our father of mediation is sitting right here with us. Thank you so much, sir, for being with us. Thank you, everyone. Thank you very much.
Can I have Arnav play the video, please? Thank you so much, Postman. Can I now request our senior founding member, Team EMW, Mr. Thangachan VP, to say a few words.
Esteemed dignitaries, founder of the House. It fills us with a great joy to celebrate the 5th anniversary of EMW here in Delhi. Over the past 5 years, the world around us has changed in many ways. New technologies, especially artificial intelligence, have opened new doors, but they have also brought with them fresh doubts and fears about our future. At the same time, human relations have become more layered and challenging. In today's fast-changing world, misunderstandings and disagreements arise more easily, more easily, and often shaped by stress, isolation, competition, and shifting social values. Conflicts are rarely black and white anymore. They are complex, involving emotions, personal histories, and unspoken expectations. Trying to resolve these modern conflicts through traditional processes often leads to more frustration than relief. The legal battles can be long, expensive, and emotionally draining. Instead of bringing healing, they sometimes deepen the wounds, leaving both sides feeling unheard and dissatisfied. While everything else in our life moves forward at lightning speed, our system for solving disputes remains slow, rigid, and heavily burdened. There is a growing gap between what people need and what the system is able to provide. In 2020, when our organization was born, the total number of pending court cases in India stood around 36 million. Today, that number has crossed 55 million. Even more troubling is that the fact that a majority of the disputes never reach the courts at all, either because people are unaware of their rights or cannot afford the costs. And even for those who do reach the courts, experience often lacks peace, compassion, and true resolution. For many years, mediation was seen as alternative to court system. But today, we know better. Mediation is not just an option. It is most suitable path for resolving disputes in a democratic and compassionate society. It is time-tested, well-structured, and efficient process that enables people to talk, listen, and arrive at peaceful solutions together. If we truly wish to build a better and more peaceful world, we must learn to understand one another. We need to listen, not just with our ears, but with our hearts. Peace does not come from legal arguments. It comes from recognizing each other as fellow human beings through mutual understanding. Such deep understanding cannot grow in an adversarial system. It can only flourish in a space where everyone is included. All voices are respected and solutions are found through mutual respect and dialogue. EMW's humble mission is to support this vision, to help the world kinder, more compassionate, and more just. We dream of a day when people speak not to fight, but to connect, a day when we hear the words of others, not as argument, but as a music filled with empathy, understanding, and peace. Thank you.
Thank you, sir. Can I now request our guest of honor, Dr. Lalit Bhasin, Senior Advocate, President, Society of Indian Law Firms, to say a few words. Also, sir, grateful for this event, sir.
Honorable Justice Sandeep Saxena, Honorable Justice Meena Bansal, Honorable Justice R. Vistata Ganju, Mr. Chetan Sharma, the learned Additional Solicitor General, Ms. Push Gupta, other dignitaries sitting here, senior members of the bar, ladies and gentlemen. Mr. Chetan Sharma said that he sees the Nari Shakti here I don't think the word Nari was appropriate. Sorry, sir. Because Shakti means Nari. And these initiatives undertaken by this unique organization, you see, is a tribute to our female in the profession who have contributed significantly. But I am a stickler for time management, therefore I won't take much time. Only half an hour has been given, allocated for about 7-8 speakers. So I don't know whether I have to speak for 1 minute or a minute and a half or 2 minutes and all that. And I saw in the functions which organized on behalf of the Bar Association of India or Society of Indian Law Firms, I seldom invite the honorable ministers, but I always invite the honorable judges. Why do I do that? Because they come 5 minutes before the prior time, and the honorable minister may not come at all. This is because that some meetings are organized. And all the honorable judges sitting here, they were here much before the scheduled time you see for that. Most of these, I think all of these honorable judges sitting here, they were not even born when I started my law practice. Therefore, what I have seen, the evolution of the profession, the evolution of the system of administration of justice, and I thought that period, the 1962 when I started my practice, it was like a golden period of the Indian legal profession and our system of administration of justice. Why I say so, and that is with a sense of responsibility, because there was no pendency of cases. Whether it was Supreme Court or whether it was High Court or District Court, you see, they were all same day judgments were being delivered, they were dictated in the open courts. You see, that was the system that we had at that point of time. But then, the multiplicity of laws, the old, outdated laws, badly drafted laws, they came into picture. With the result, remarkable, you see, increase in the volume of litigation. Litigation system has failed, and this was said by, you see, Sattelwar, when he was the Attorney General. He said this system has broken down because we have too many cases coming up. An alternate was thought of in the form of ADR, that is the Arbitration Act. In India, arbitration has failed to take off, and I can say that with some certainty, daring certainty, it has failed to take off. The reason can be many. Reason can be lack of proper institutional arbitration. It is ad hoc arbitration at the moment, which has become very expensive, very prolonged, and not less than, you see, the time taken in litigation. So, what is the way out? It was said by Push, you see, Push जी मैं आपका रेफरेंस दे रहा हूँ. आपने बोला कि the President of India at that great function which you had, but she said something which was remarkable. She said, and that was not a message to the legal community, it was a message which is all over the country. Let your differences not become disputes. This is what the President of India said. What does it mean? What does it imply? That there has to be a change in the mindset of people. So let us not talk, you see, just about judges and lawyers and other people for settling about disputes. This message has to go down, you see, a general awareness has to be created. And that is where the role of, we have the eminent representative here of the Bar Council of Delhi. I happen to be the oldest living chairman of the Bar Council of Delhi. And during my tenure, from 1973 to 74, we embarked upon so many, you see, initiatives. And one initiative was, I still remember, and that was quite successful at that point of time, because after that it was not pursued by the leadership of the Bar Council. That was Samjhauta. Idea was to create that spirit of Samjhauta. And what does Justice Krishna here, you see, he said in 1978, message to the lawyers that when you settle a dispute, when you win a case, that is very satisfying for you. But when you settle a case, it is divine. Wow. That is what you see Justice Krishna was. And what Lord Denning said, very openly, frankly, that a bad settlement is better than successful litigation. Wonderful. A bad settlement is better than successful litigation. I don't want to use the word phraseology, legal terminology like litigation, arbitration, mediation, because I feel as soon as it takes a legal shape, there are bound to be disputes even about the interpretation of that law. You have a new Mediation Act. It's a welcome step, much needed step. But I shudder to think, you see, that possibly the interpretation of various provisions will also lead to some disputes and all that. What is required is a change in the mindset of people, and that has to come from the law schools. That is again where the responsibility of the Bar Council comes in. Because they lay down, you see, what should be the curriculum of the law school. That is where you see the skill, developing skill in negotiations. That should be one of the items, you see, which should be there. Therefore, my appeal to all of you is, have that spirit of Samjhauta, which was rightly pointed out in the previous session by the representative of Panchayats, you see. That is our culture, that is our tradition, that is our heritage, consensual form of dispute resolution, to which we have given a go-by when the British came in. So we can't do away with that because now it is a part of our constitutional framework. We have to live. But within the framework also, what can be done, what can be achieved is try to create that spirit of Samjhauta. Thank you very much.
Thank you so much, sir, for those inspiring words. Can I now request the guest of honor, Justice Tara Gandu, for a few words, please?
Thank you. Although this was, in fairness, this was sprung on us late last evening, so not really well prepared. I don't think I need to say very much. All of you here, well, firstly, good morning, Justice Seva, Justice Bansal, Ketan Sharma ji, who's reminded me of the traffic that we have in Delhi, Justice Sudhir Jain ji, Justice Mittal, Veena ma'am, and of course, therefore, not to forget the grand old man of our, really need to say too much. We have a room full of experts. And let me start by saying that from a time when mediation was feared, I mean feared by the lawyers, they thought it's going to come and take over their business and their clients, to a time when mediation is preferred. This is a huge change that we've seen in the last, I think, 15 or 20 years. And it is thanks to all our mediator trainers, it's thanks to institutions like EMW and various institutions which have led to this fear becoming something which is something we need to move forward with. So kudos to all of you, kudos to the Mediation Center. One of the issues which was discussed when we met for this event was that pre-litigation mediation has not taken off. Completely agree, but one of the major reasons that it has not taken off is the lack of awareness. Sitting in court every day, we try cajole, tell parties very clearly see it's a small gap, it's some small issue which can get resolved to go for mediation. They all look puzzled, and this is court mediation. They are not sure, they are unsure of their lawyers, they are unsure of what this process is. So awareness. That's what I would say in short. If you want pre-litigation mediation to come, then as was said, when the differences become disputes, that's where the issue arises. So you have to catch them before, and things like panchayat initiative and any initiative that is taken up, it has to be done right at the stage where it's just beginning to bloom. So and how would you create awareness? How do you get people to know about pre-litigation mediation? Actually, really speaking, nobody knows. So you need to take this issue, and whether it's the Bar Council, whether it's the mediation centers, whether it's private institutions, you need to take it forward. Please tell people about it. I'm sure other than a few hundred people or a few thousand people know about it, but what about the rest? So please do that. And just two more points. I'll talk about domain expertise, which was briefly touched on, which is something we find that in court at least. Now we refer a dispute to mediation, and it comes back with an agreement which is unenforceable. Although I must say, this has become much less over the last few years, but there is that odd agreement which comes, which is completely unenforceable, which means that the dispute was dealt with somebody who's not a domain expert. So this needs to be, people need, so that's why we need mediators from all facets of practice. We need that. And last but not the least, training for judges. I spent, there was an event last evening where there was a very senior trainer, mediator from the US. He's been training mediators for all across the world for years. And he talked about this, we talked about this today. Some of us who are lucky enough to be trained mediators know this, that it definitely helps. It does help when you have that training, you have that mindset, because it is a mindset. It's not just some two people sitting together and saying, okay, let's just resolve this, it's easy. No, it's 40 hours of good training. And over and above that, courses or events that we use to help on the stage. On the dais, we are supposed to decide, yes. However, the mediator in us does creep out every now and then. And I think it's important because the very fact that I do think like that, for instance, just from personal experience, makes me think a little bit longer on whether this can get resolved. And so I would advocate at least a short spell for all judges as well. Thank you all for having me here. Thank you.
Thank you so much, ma'am. Rightly said, our fear slowly becoming the strength. Can I now request our guest of honor, Justice Neena Krishna Bansal, please address the gathering.
Good morning, everybody. As you all can see, I'm the last speaker, and therefore my speech is going to be very, very short, because obviously we want to listen to Justice Ashkeva, who's been associated with this mediation movement since beginning, and we know and understand the commitment of His Lordship, who is, very spearheaded this. I think the initiative that was started in the High Court was unique, and it took off because there was so much of support from people who had a right mindset. With this, I would just like to say a few things that it was an idea. Mediation, when it was introduced in 2005, it was only an idea which has grown into such a big movement because of the cooperation and the understanding between all stakeholders. So everybody, be it on this side of the bench or that side, all have been on the same page to be where we are. We've taken a small and firm steps, but this is the beginning, as I think in the first session it was said that in 20 years we have achieved that from here we are going to fly. The big thing is that the reach is going beyond India. As has been said, EMW has members from outside India, which is a big thing, because unless we all understand different cultures, we would not be able to converge to one point. There is 2-3 things which are small but important. That first and foremost, when we talk of mediation, it is not limited to being a dispute resolution mechanism. It is something where we work on individuals, not on institutions. Whether we succeed or not, the kind of training that is given, it does a lot for you as an individual. So don't begin from saying that it is something which gives something to everybody. Anybody who undergoes the training, the work and the profession comes later, but as a training, the self-evolution which this training brings in can only be realized by those who have undergone it. It brings in a complete personality change, as has been said in the earlier session. It helps you not only in your profession, be it an advocate or a judge, to understand litigation better, but it brings in a lot of empowerment of an individual, which I say is the biggest strength of mediation. Let us not measure in terms of number of cases that are getting resolved, but look at it, how many people are being brought at peace. Whether you succeed or not is not important, but if you understand your position, you understand the dispute, I think more than half the battle is won in bringing the peace. Pushpa said that their acronym is TEAM, team, that is how they all work, but I think that's the mantra for the mediation, because the way we looked at it was together each achieves more. So the more we all learn to appreciate each other and stop looking at each other as adversaries, I think it will make our journey much more simple and easier, and of course we'll be much quicker in moving forward. Just in the end, I would say that we have been able to achieve somewhat recognition where court litigation is concerned, but our Achilles heel remains to be free litigation. Of course, our Samadhan has been working on that area. Some initiatives were also taken at the district court level, but as each one of us as an ambassador of mediator doesn't need a platform. Each one of us, whenever we come across any kind of conflict situation, differences, each one, the mediator and as Tara said, must come out, and we must not look for forums, platforms, but start from wherever we are. We don't need big institutions, we only need people, understanding and cohesiveness, which we have achieved when we see so many people pan-India sitting here. But best wishes and good luck, and I'm sure we'll be making progress further. I'll end by taking this moment to congratulate Justice Deva, Designate Chief Justice, Madhya. I am extremely happy if he happens to be my batchmate.
Thank you so much.
Thank you so much, ma'am. As rightly pointed out, the strength of mediation, self-evolution and empowerment. Can I now request our guest of honor, Justice Anisa Deva, to say a few words, please? Chief guest, please.
Justice Meena Bansal, Justice Sara Ganju, Justice High Court of Delhi, Justice G.P. Mittal, Dr. Sudeep Jain, Dr. Justice Sudeep Jain, former judges of Delhi High Court, Mr. Chetan Sharma, Mr. Rajesh Mishra, Secretary Bar Council of Delhi, Veena Rajaji, Organizing Secretary Samadhan, and Dharmendra Rathore, the Registrar General High Court of Madhya Pradesh. Of course, Mr. Lalit Bhasin, President of the Society of Indian Law Firms. Well, he said that most of us would have been born when he started practicing, he's right at that. But my association with him goes when I was still a toddler because of the Bar Council connection. Mr. Sankanchan, Senior Founder Member, Ms. Push Gupta, Coordinator in the Chief Team of E-Mediation Writings. Ladies and gentlemen, well, taking a cue from what Mr. Bhasin said, he corrected Mr. Sharma and said, Nari Shakti is actually Shakti. And he also said, we've all been given 3 minutes each, because I counted 30 minutes and there were 10 speakers, and luckily 3 speakers haven't come, so we get 3.5 minutes each. So, but there are a lot of things which are happening, and I had a long speech written, but I think I'll follow the cue of my colleagues from the High Court and not speak from what and even Mr. Bhasin, I noticed he came up with his papers but he didn't use them to speak. And I find that all of you are trained mediators, so I had prepared a little bit of thing on what mediation is and things like that, but I don't think that's required over here. There were certain things, and what was pointed out that Samadhan is unique. In Madhya Pradesh, I found out, I had the experience of Delhi High Court, and I've gone to Madhya Pradesh. Madhya Pradesh also has very active mediation system. But completely different. It's judges oriented, judges run, and what I found there was like, and I found why Samadhan is successful. Because you see, though it's not a very happy expression to use, it's chipak jaate. Mediators get stuck to you, they will make sure that you settle your dispute and don't go. In Madhya Pradesh, what I found was, first sitting, one of the parties don't come, we'll get a report, non-starter. Not even effort, why a party didn't come, what is the issue, and like I pointed out when Mr. Sharma had put up a question, one of the mediators had a whole evidence recorded of parties. He was trying to adjudicate the dispute. That's not the role of a mediator. So Samadhan is very successful because run by all of you. Even the mediation here in Delhi is very successful, E-Mediation Writings. Look at the training sessions which are happening. Now nowhere else in the country this happens. This is something akin to what is happening world over in the Western countries, but not in India. Apart from Delhi, I don't think any other state is actually doing it. We have somebody from Telangana. I don't know whether it happens in Telangana or not. You're from Telangana, right? No, you're from? Andhra Pradesh. Okay. So Andhra Pradesh, I don't know whether such kind of training sessions happen in Andhra Pradesh or not. But Delhi, I find a lot of training sessions like this happening. Now, there was an issue raised with regard to amendment of Order 23. Well, yes, amendment is required. We would like to incorporate mediation as an in-house training session, starting from law school. That is where the Bar Council of India role can come in. And another suggestion I would like to make to the Bar Council. You see, mediation is coming up as a mediation practice. There are people who are shifting from regular court practice into mediation. There is no body governing that field at the moment. So if somebody goes into a mediation practice and say misuses that, we have arbitration practice. There are people who are giving up completely their law courts and going into arbitration. There are people who are giving up and going into mediation. Bar Council can look at probably bringing in a regime where that can be monitored, especially by lawyer-turned mediators. that there could be some form of monitoring, some form of an organization which is like a bar council, a parent body to monitor all these things. Mr. Karmakar mentioned about mediation in panchayats. In Madhya Pradesh, there is a unique system. We have community mediation. Now there are community people who have nothing to do with law. Retired professors, retired vice chancellors, doctors, they all come in as community mediators. Now they are trained in mediation. For example, if there is a dispute between two doctors, or dispute between a patient and a doctor, so they, or for example, a dispute which happens in a locality, if there is a trained community mediator, the dispute goes there and that gets settled. Even the SP of Indore has given a room, a space. A community hall has been converted into a community a center where the community mediators come in. 2 days in a week, and they resolve disputes, petty disputes, fight between two neighbors, parking issues. So those kind of disputes, they prevent the dispute from coming to court. Mr. Bhasin talked of pendency of cases, and he said we started in a situation where there was no pendency, but now pendency has increased. Well, we can't say that you can blame the legal system. It's not that the legal system has failed. I think, and which is something which at least I have a personal view, that our legal system has been successful, and that is why we have so many cases. And there is a second, that every coin has two sides to a coin. You see, in a Western country, nobody can afford to go to court. I remember in '92 when I was there, part of a training program there, I was working in a solicitor's firm where there was an insurance dispute and the claim was £4,000. So there was an insurance claim of £4,000 which was being denied to a party. We went into litigation, matter reached the High Court. At the end, the cost of the litigation was £52,000. And that is where I feel that our society has been successful, that we've been able to reach out to the poor and ensure that he can come to court. We have Lok Adalats, we have legal aid services provided. Now, if we make litigation expensive, people will stay away from court. The fact that there is pendency, the fact that there is a lot of litigation, there is explosion of documents, that is because people still trust the legal system. They feel that yes, our dispute can still be resolved. Yes, there are a lot of things we need to do in terms of reducing the docket, in terms of ensuring that person who comes to court gets a resolution of dispute as early as possible. And that is where the mediation comes in, plays a very major role. There were alternative dispute resolutions had been sort of like Lok Adalats were there, then arbitration came in a big way. But then we realized that from 1940 to the 96 Arbitration Act, that today we are at a stage where mediation is sort of taking over all forms of alternative dispute resolution and resolving disputes. And you as mediators, who better than you to know, that when you finish one or settle one dispute, Mr. Bhasin just quoted the Honorable Excellency, the President of India, who said that let differences not become disputes. Now that is where mediators' role comes in. If you have a pre-litigation dispute, you are finishing that dispute. Even if there is a case going to court and you settle that dispute, you are not settling just one dispute. You are settling several disputes. It is not one case, because we know that a civil suit, for example, gives rise to we don't know how many applications. Each application, if it's a contested, real contested suit, will lead to a first appeal, second appeal, then even to the SLP, to the Supreme Court. Now, if you finish one dispute, you finish several disputes. Now, normally I give that example of a Sardar family in all my speeches. Now, I'll give another example from Madhya Pradesh, which I recently got settled. And this was exploded on the YouTube. A 22-year-old dispute got resolved in minutes. Again, a partition suit which had come to court in my court, and this had arisen from an execution stage, where execution petition was dismissed as being time barred, etc. by the court, and dispute between brothers in a partition suit, we all know, so long as the properties are divided, you continue to remain joint. Now, on one side was the family of a brother because he passed away in those 22 years. On the other side were other brothers. So I simply, again, this is something which I wanted to emphasize that if judges are trained mediators, they will help them resolve disputes. So I asked the parties, their share was not an issue. One side had 22%, the other had 78% share. So I said, all right, one of you fix a value to the property and the other will choose. So the person who had 22, he said the property is worth 5 crores. So the other guy said, let me get back. He came back next day, he said, no, it is 12 crores. So I told the one who had 22% share, I said, your choice now. You fixed it at 5, he fixed it at 22. If it was actually 5, you're getting more than double your share. He said, I agreed to sell my share. The moment that happened, the issue got resolved. They said 23-year-old disputes got resolved in minutes. So that is where a trained mediator comes in. So I think all lawyers, all judges must receive training, some form of training or the other in mediation. Though we are all qualified, yes, when you play the role of a mediator, because this is what happens and this is what we were trained, that you wear two hats. Suddenly you have a hat of a lawyer, you take it off, go into a mediation room, wear the hat of a mediator. And also the lawyer taking a case to court, to a mediator, you play a very different role. And in India, this is where I say we're distinct from the Western jurisdictions. We are all used to carrying several hats to court. As a lawyer, you have 20 briefs. So one brief, one hat, another court, another brief, plaintiff, defendant, petitioner, respondent, appellant, you're all wearing different hats. In England, I remember solicitor had come here for a session and I asked him, I said, what's your plan? He said, I have to go back, I have a major trial to prepare. I need 15 days time to prepare one trial. And I said, over here, lawyers would have conducted 15 trials in a day. They just one lawyer, cross-examining, another witness, examining chief. So we all, as mediators, perform that. And if you carry several hats and you know how to change hats at the drop of a second, at the drop of a hat. And I remember, I'm forgetting, I don't know whether it was Mr. Ramaswamy or a very senior advocate who was arguing in the Supreme Court and his advocate on record was pulling his gown. He would do this. So he carried on, he kept pulling, he would do this. So after 15 minutes when the arguments were over, so the advocate said, Sir, aap kya kar rahe ho? Hum to dusri side ke hain. I don't know. He says, my lord, this is the maximum that can be said against me. Now he started arguing the other side. So that's the skill that we all possess. So taking it through, I think I've overshot from the 3.5 minutes also. I've not opened my papers, but thank you very much. It was lovely to be here.
Thank you, sir, and hats off for pointing out on all the hats that the lawyers have.
Just attempted to intervene here. I forgot to mention that when I was the chairman of the Bar Council of Delhi, Mr. Sanjeev Sajde's respected father, he was my colleague and we were very good friends. And he and I both were instrumental in introducing that scheme of Samjhauta during the Bar Council. And he was a member of the Bar Council of India nominated by Delhi Bar Council. Yes. One other comment I have, sir. You have said that people of India have faith in our system. Yes, they have faith. But is that faith, you see, being repaid in the sense, are our people getting justice? Our emphasis seems to be on law, which was not there earlier. Our constitution says justice, economic, social, political, and all that. After that, there is no word, no mention of justice. It is only law. With the result, you see that we have this huge tendency of cases. I marvel, you see, at the honorable judges. I am a witness myself almost every day. I am in Delhi High Court. The honorable judges sitting type in 5:30, trying to dispose of at least 30, 40 out of those 100 or 120 cases which are listed. They are unable to do so, physically impossible. So what is the way out? I was on the high table with the Honorable Chief Justice and Dhananjay Chandrachud in Symbiosis in Pune convocation. So he said that this is what we have done, e-filing and all that, ease of everything it has reduced the expenses, reduced everything, and virtual hearings and all, this is what has happened. So my turn came with it as a concluding address. So I said, your Lordship is right, but what about the disposal of the cases? You have made ease of filing, but what about this disposal of the matters? 5 crores have become 6 crores now. So how do we tackle that? That is why, you see, in my opening remarks, I have said that our system, you see, is breaking down so far as litigation is concerned. We have to do something. Artificial intelligence will not help. It will help you as a research tool, but it will not help you in disposal of cases. Yes, you want something on natural justice, click something, that will all, case law will come about that. But then that case law has to be applied, and that application of mine has to come from here, not from AI. So how do we tackle using the disposal of the cases? That will bring justice to our citizens. We have cases, high-profile cases, political cases, religious matters cases, everything coming up before the Honorable Supreme Court and before the High Court. What about the cases of the ordinary citizens? Those cases don't come up at all. Dates after dates. And the dates are then given by the reader. Thank you.
Thank you, sir.
This certainly calls for a response, sir. Sorry. Though I agree with you, but you see, it takes time. Now, I'll give a simple example. In Madhya Pradesh, we have 3 benches. In Indore, we have only 6 judges. And the pendency in Indore is 1 lakh cases, which is equivalent to the pendency in Delhi High Court. Just the Indore bench. This is Gwalior. In Indore, we have 9 judges. Pendency is 1.5 lakhs. Jabalpur, we have now 15 judges. Luckily, 3 more were sworn in yesterday. And we have a pendency of 2.5 lakh cases. So, and every day, the list reaches 300, 350 cases. So, in vacation, one of the judges told me, the vacation judge was sitting on Thursday. He said, sir, I'm sitting in DB, can I sit on Friday as a single judge? I said, why, what happened? He said, I've got 500 bail applications listed before. So, you see, that is an issue we're grappling with. And of course, you're right, AI is not a replacement to judges. I've in fact written a thesis on that. But there are, again, we'll be transgressing. In one simple example, I say, if you apply an AI tool to decide a case, where do you file an appeal? And what do you file an appeal on? You file an appeal on law, or you file an appeal on the coding of the system? Those are several issues which come up. But AI does help. For example, again, in vacations in Madhya Pradesh, on one of the benches, there is no judge present physically. So one judge sitting in Jabalpur is going to hear cases of Indore bench during that vacation through VC. So that's where we are using technology. We certainly not, you can't use technology to replace judges. But you're right, and I had in my speech mentioned several things government is also doing, like commercial court site has mandated that 6 months for disposal of commercial cases. And since I transgressed from my speech, we were bringing, look, foreign companies want to come in. But they want security of their asset, they want quicker repatriation of their money, their profits. So we are doing things, even the courts are on board when we come to ease of doing business. We have special benches like Delhi High Court has the IP bench. We have expedited matters in commercial cases. We're trying to do things, we're all trying to do our bit. But yes, we're grappling with the system where the system is overloaded. I would not say, we'll certainly not let it fail, if that's a concern. We all, and that is what Justice Ganju was just mentioning, she was saying, I've come here but I have loads of orders to correct. You see, what we see and what the general public sees is 10:30 to 4:30 court hours. I remember I in vacation sat up to 12 in the night on a vacation bench in court. You can imagine when the staff would go, because you do those orders, you have to correct the orders, you have to, and fellows do make mistakes, you correct the orders, then you have to upload the order so that the litigant has the order in hand. You grant bail to somebody, you grant stay to somebody, but he doesn't get the order in hand, it's virtually as if he good as not given. And then next morning, when you come to court and you have a docket of 60 cases, you have to read those 60 files. We don't read the files as a lawyer would, but we at least spend some time on reading the file. And in vacation, when I sat in vacation, I've always in Delhi High Court used an e-court. In Madhya Pradesh also, luckily the systems were there and using an e-court. And I give this as an example. I sat in vacation once, early on when I was in Delhi High Court, and I had about 90 matters listed before me, which is normal before a vacation time. They don't take that much time because they either stay or pay. But during vacation, files were not being scanned then. They were physical files. So I said, let me time myself in the time spent in administration. So I was timing that I would, from picking up a file from the jhola, they used to come in a bag, to opening the thread, finish your reading, closing the thread and putting in the file bag would take me a minute and a half. So 90 cases into a minute and a half was the time I was doing in opening and closing the thread. Which is if you have a digital file, you click a button, you're on to the next file. So that is where technology is helping us. It's helping lawyers. We see lawyers with those digital tools today. I remember when I was a lawyer, when I started practice as a young lawyer I started with my dad only. I didn't have a munshi allocated to me, so I had to carry my own files. So I would have a file with about 5 or 6 books. We didn't even have a photocopy facility at that time. But you would carry those books into court. The tellers used to go into court. The tellers used to be littered with so-and-so company, so-and-so law firm in court. So that is where technology is helping us. Yes, we are having a fine. We requested the government to increase the strength in the judges. The difficulty is finding good lawyers. So some of the lawyers are now refusing to come on this side. That's happening. Earlier it was unheard of. Nobody would refuse. But today, some senior advocates are refusing to come on this side. Because it's becoming a sort of a niche practice. So you don't want to give up your practice and come onto the side. So these are things where you all as mediators play a very major role. So, sorry, I don't know.
Thank you, sir. Supportive. This, what I am going to say affects you also. The Lordship mentioned to see about the government's role and all that. Now, you know it because we see you in the High Court, one court to another court. Government is the largest litigant. So when we talk about change of the mindset, first change has to come from the government, you see. Case of dismissal of one government servant will be taken right up to the Supreme Court, you see. So you are lost in the High Court, you are brought before the Union Bench and you go, you see, SLP. Therefore, 60 to 70% litigation is around the government, you see, and the government's role. Therefore, a change in mindset of the government would greatly help in reducing the arrears. No one wants. No, they don't want to litigate, sir. There is a reason. I have some public sector clients, so I tell them, why don't we settle the disputes? This is because you have a weak case or something. They say, so let the verdict come from the court. Tomorrow there may be a CBI inquiry why you have settled the matter, and all those things will happen. Therefore, that change in mindset has to come, and it has to come from the schools also, from your families also. I have my wife sitting here, Neena Gupta. She is a trained mediator, and she makes sure that our differences do not become disputes. But what is very significant is that after this Operation Sindoor, what the Honorable Prime Minister said, he said, we have used Shakti. We could have gone much beyond, but Shakti combined with Sanyam. Sanyam. So that is a form of, you see, that, okay, you have agreed to do something. There is that spirit of, you see, saying that, okay, whatever we wanted to achieve, we have achieved, but now we will stop. It is like an inbuilt system, you see, that, okay, now you don't want to carry the dispute, you see, to be aggravated. So Shakti and Sanyam also involve some sort of mediation, something like inbuilt system. That is the spirit we have to follow, I think, all over. Show our strength, but at the same time, mediate also. Thank you.
Thank you so much, sir. This has turned out to be a very powerful panel discussion. Moving forward, can I now request our dignitaries to give us the honor and release the 20th international edition of the EMW magazine. The magazine is one of the first ever to have introduced 200 words, proverbs, idioms related to mediation. Can I also have the coordinators to this edition on stage, please? Requesting Ms. Meena Khare, Senior Founder Member. Can I have Chetan sir, please? Requesting Mr. George Malhotra, Senior Coordinator from Kerala, Ms. Ruchi Khurana, Mr. Arnav Tandon, who have been the backbone of this edition. Can I request Abhi sir as well? Veena ma'am, can I have you on stage as well, please? We are missing Arnav Tandon here, who's also been a part of this edition. Thank you so much. It's my privilege to further announce that we're also launching two unique initiatives. One being the Mindset series, a workshop on soft skills, which is the brainchild of Ms. Push Gupta. And I would like to thank Ms. Bhima Bhandari, Mr. George Malhotra from Kerala, Anup Shrivastava from Allahabad, and K.S. Sarma, the life skills coach, for their immense contributions in this initiative. This initiative is all about 40 hours of brainstorming before the 40 hours of mediation training to learn the key interpersonal soft skills and mediation wisdoms. Our second initiative is one of a kind, Sulha Setu, Shehar Se Gaon Tak, where we have tried to take mediation to the grassroots level in India, all the way to our villages. To help us achieve this goal, we would like to thank Mr. Saurav Karmakar, who is the founder of Panchayat Resolution Center. Can we have Mr. Karmakar on stage, please? He's played an integral role to help us achieve this vision, to take EMW all the way to the villages. We would also like to thank Ms. Amulya Gupta for her creative brainstorming in this initiative. Can I have Amulya Gupta on stage, please? With this, I would like to thank the presence of all our judges who have graced this occasion. Can I request Ms. Veena Khare along with Ms. Ruchi Khurana to present the scroll of honor to Justice Sanjeev Sachdeva, please. Can I have Ms. Praveena Gautam and Ms. Pooja Anand, Senior Mediators of the E-Mediation team? Requesting Ms. Praveena Gautam and Pooja Anand, Senior Mediators, to present the scroll of honor to Justice Deena Krishna Balsam. Requesting Ms. Anil Katiyar, Senior Mediator, Supreme Court, and Ms. Saroj to present the scroll of honor to Justice Tara V. Ganju, please. Requesting Senior Advocate Priya Kumar and Ms. Vijaya. Senior Advocate Priya Kumar and Ms. Vijaya to present the scroll of honor to Dr. Lalit Bhasin. I would like to thank all our judges, all the esteemed guests on the stage. Can I request your worship to thank you for please. And meanwhile, we'll set up for the second panel discussion. Can I have the next please?
At that point of time,
Hi, hello everyone. Can you please be seated? Because our panelists will get late. Please get your tea on your tables and on your sofas. Please get your tea and sit so that our panelists don't have to wait for very long. They are already quite delayed. May I request everybody to just come and get seated, please? May I request our panelists to also be here? Mr. Sumit Kumar Jha, additional DCP. Dr. Bhalla, Dr. A.K. Bhalla, is he here? Ms. Sumit Kapoor is here. Okay, and Professor Anita is here. Amit Grover, he's also here. Mandeep Kaur, Ms. Mandeep Kaur, are you here? May I request you all to come and sit on the dais so that we'll try to attract the audience back. Please come. Ms. Mandeep Kaur. Ms. Mandeep Kaur, are you in? Okay, we are starting the next session. Please get your tea. Please come and sit on the dais. Ms. Sadi Gupta. May I request the audience to come and get seated, get your teas here only. May I request the audience to come and sit over here. Please be seated.
be seated. Please be seated, the session is starting. Bring your cup of tea to the table. Hotel staff, please stop the service. Please stop the service. Everyone to be seated. Mishra, please sit down. Mr. Rajesh Mishra, please have seats now. If you will sit, then everyone else will sit also. Thank you.
Thank you, sir. So I welcome you all to this wonderful panel discussion. It is a food for thought. We are going to fill our minds with thoughts before we fill our tummies. So the lunch is still waiting. And may I now request the dignitaries already here. I would like to welcome them. So may I request Mr. Deepak Kumar Dhingra, mediator and senior trainer, President Labour Law Association, to welcome Mr. Sunil Kumar Jha, additional DCP. May I now request Ruchi Khurana, advocate mediator, to welcome Professor and Dr. A.K. Bhalla. He's on the way. Okay. So then may I request Ruchi to welcome Professor Nija from IIM. Achha. May I request Ms. Swati Gupta? May I request Sarika Jetli, advocate mediator, to welcome Ms. Swati Gupta, who's from the State Bank of India, a director. Aditi, may I request you to please welcome Ms. Swati Gupta. May I request Prerna Kohli, advocate mediator, to welcome Ms. Sumit Kapoor, Executive Director, Pension Fund Regulatory and Development Authority. Is Anupama Naran here? May I request you to welcome Mr. Amit Grover from Delhi. He's a joint secretary from Delhi and District Cricket Association. Please. May I request Saroj Bidor, advocate mediator, to welcome Ms. Mandeep Kaur, Senior Vice President and Legal Head of DLF. A couple of our panelists were able to meet, so now we are ready to start. The topic of this panel discussion is the unspoken solution, soft skills for real conflict, equipping every mind with tools for understanding, dialogue and de-escalation. So in today's session, we are really raising the question, when we talk to our friends, neighbors, strangers, co-workers, are we really communicating? We are talking, but are we really communicating? So spiritual gurus and life coaches, they say that hell or heaven lies in your own 5 foot body. The eyes, they speak louder than words. Your voice is really a reflection of what's in your heart, whether it's chaos or peace. That's what your voice says. Your heart can sound as vast as the ocean. So they say, sometimes they say, he's got such a big heart from the way the person behaves and speaks. So communication is not just verbal. It could be verbal or it could be non-verbal. A good communication really achieves the objective of building interpersonal relationships, to enhance human behavior, and more importantly, it's a dialogue. It's a circular process, giving and receiving. It's not a monologue. So when we try to build bridges or bridge the gaps between people who have misunderstandings, we can see how communication is different from talking. Words and sentences spoken may not really give the message that was intended. So the idea is to understand what is communication, which is really sharing of information between two people or more, and to reach a common understanding. Think of a real conflict. You may have one at home. Maybe, with a child who says no. Or a worker who is not very productive at work. Or, in a hierarchy situation, a senior and junior situation. So when you are dealing with real conflict, how can you express honestly? If you have to go and express yourself honestly, what would you say to them? Indian philosopher J. Krishnamurti says, the highest form of human intelligence is the ability to observe without evaluation. So, to communicate honestly from your heart without expressing, a judgment or an opinion is communication. And the biggest skill in conflict situation is to really identify facts from opinion. And that's what a skilled mediator or a soft skills trainer would do. So today we would like to discuss how we can build effective communication and a mindset of soft skills, understanding different dimensions of human psyche, developing emotional intelligence. To create connection outside, we really need to first get clarity inside and to be harmonious within. The idea is to fix the issue, not the person. So with that, I think I would like to kickstart this discussion without any further ado. And may I just have a round of opening remarks to start with. Maybe just 2 minutes so that then we can have a larger discussion. So we can just talk about the kind of conflicts that you see in your organization. So can we start from this side and can you just talk about the conflict that you see in your organization? What are the kind of interpersonal relationship issues or something that is becoming a hurdle and obstacle to working within the organization?
Thanks a lot. First of all, good afternoon everyone. Thanks for giving this opportunity of being here within the honorable judges, eminent our colleagues from the fraternity and the other speakers, friends. It is giving the opportunity of learning that how the soft skill happens in our day-to-day life as well as in our professional life. I have been associated with real estate industry for last almost 30 years and effectively have been internal part of the real estate industry for last 17 years. Where I feel personally that many things the stakes are too high. The stakes are high not only at the end user, a customer, the stakes are high of the teams which are working to achieve that. The tenure to achieve the last end, the end product, takes years, maybe decades also. So lots of patience is required, lots of efforts are required, interplay between the departments, teams, and further communicating with the end user. At that time, all our personal skills, soft skills, our behaviors really matters a lot. I've seen in our industry, when we starting from the acquisition of a land, taking approvals, layouts being made, going to different industries, studying them, going to different departments, going to different authorities for getting the approvals, impatience, that goes very high. When patient goes high at the manager levels also, highest management levels also, and goes down. So at that time, the politeness, patience, the understanding plays a vital role. Further, the construction stages itself is very, very, that is putting a noise on your brains, on your things, which you take back. Then comes the main major issue in this industry is the end user. End user is a customer. End user is a person who's investing his hard-earned entire life savings in this industry, in that thing which he doesn't even know where it will exist, how it will come up as compared to other commodities which we go and buy. So that person who just parts with initial amount from his pocket, from very first day, he has got lots of queries. That queries keeps on increasing in his mind. He keeps on just coming back to the front desk persons, marketing people, the sales people, whether his investment is safe or not. In the night when he sees the news, in the morning he just calls up endlessly. So at that level of that managerial level persons, when those level persons have the patience to hear them, to politely address their issues, to apologetic, that really makes a difference if that soft skills are there. That we've witnessed it lots of times, that if this is there, we end up the many issues, we bridge up many things there than that only. But if those persons, those individuals at the lower level, in their daily life or professional life, they are not so trained with having that patience, that polite attitude, the polite behavior, the bridges increases. That's the first stage itself, probably, which leads and we end up in all these consumer forums, national commissions, courts, and all those things. And nowadays, because of social media and all that, it becomes multiplied in a day. Word of mouth means a lot. I can share one or two experiences which I just was brainstorming.
As a legal head, I am very sure that you are overburdened with these kind of issues, with consumer issues, and the different stages in which you must be facing, so many conflicts. So please come to your experiences in a while, and thanks for sharing your rich experience so far. May I now request Dr. Nija Pandey, who is also got close to 30 years of academic and leadership experience across national and international institutions, IIM, JP Business School, etc., to share with us certain academic and governance issues that you may be coming across in just 2 minutes as an opening remark.
Thank you so much. A lot of gratitude for inviting me here. I came early to listen to the panels and the inaugural speeches, and it's so empowering to appreciate the mediator's role. As a professor, as a teacher from last about 35 years, I have been teaching from 1991 onwards from Ferguson College, Pune to IIM Lucknow where I am. I think, communication is something extremely important. A faculty is known for the competence that I bring to the table, whether I'm a professor of leadership, like I am, leadership and communication I teach, or a finance professor. But along with that, communication is also as critical. Just to give you a very small example, what happened in the morning today as I was coming to this place, one of my students whom I taught 25 years back, the year I joined IIM Lucknow, 26 years back, he's a absolutely international top CEO, and he's written a book about which he announced on LinkedIn. So as I was coming, I wrote a small message for him on the LinkedIn that congratulations so and so. I'm sure that in this book there would be a lot of substance and style. I'm confident that the book will have a lot of substance and style. Now the response which I got is something which I want to share so that you know that through our communication, what kind of an amazing impact we are making, which is getting embedded in the minds of the people who interact with us. Now this boy, because I taught him when he was a young lad of 24, writes to me that, ma'am, you are the one who started for me my love affair with books. I still remember the book Siddharth by Herman S. which you gave me, where you wrote that to your self-discovery journey, and when I reached Cape Town and I messaged you that which book should I read, you said things fall apart. Can you imagine that somebody whom I taught 26 years back gifted a book, wrote a word there, remembers verbatim when he himself. So this is the power of communication which I have seen as a teacher. Absolutely, unbelievably, you can think like a philosopher, but if you cannot communicate like one, I think the job is half done. So I'm so happy for the theme that you picked up for this panel, and I would want to pitch in wherever you would want me to.
Thank you for being here. Now we are coming to your country's biggest area of conflict, and no wonder, the Deputy Commissioner could not come himself, but we are so happy to see you as a young additional DCP to be with us, Mr. Sumit Kumar Jha. Can you just tell us the kind of chaos that we face on a daily basis?
Thank you so much, ma'am, for having me here in between a group of such a big legal luminaries out here. So I'll just give you a perspective of what we do as police officers on a daily basis. So every day, let me talk to you about an average police station in Delhi having density of population of about 25-30 lakhs of population in a district and 5 lakhs in a police station. So we receive on and around 60-70 PCR calls on a daily basis in one single police station. So there are 60-70 cases of conflicts, as ma'am rightly said. 90% of those conflicts are very petty conflicts, which only requires these soft skills and can be dealt with mediation. So mediation is like our bread and butter for a police officer or a policeman in the field. There can be issues as petty as, dropping of water from an AC pipe to on somebody, on a neighbor, and it can be as petty as parking of a scooty. And we have got such kind of disputes, and we are getting it on a daily basis. And like dial 112 is available for everyone. Anybody feeling, we have got the most ridiculous calls on dial 112, which I would not even like to share here. Finding a snake in a lawn, so for that also police gets a PCR call. But then I'll just like to give you a perspective of what soft skills has to do with mediation. During my training, I was in Shadra district in Simapuri, and Simapuri is a heavy crime police station. So there we got a late night call from a lady that मेरा पति जो है वो आज बहुत दारू पी के आया है और मुझे पीट रहा है. So we got a call, we responded, we brought the husband to the police station, the wife to the police station, and I was there. In our probation, we are given a charge of SHO, to act as SHO for 3 months. So I was the SHO, I was sitting on the chair, I was just sitting on the chair. The husband and wife came in, So they were both together standing, one was narrating her version of story, the husband was narrating his version of story, both had conflicts. So first thing I did was I separated them 5 meters apart. So you speak from that end, you speak from that end. And I was very calmly listening to them. So there is a, if we plot, I'm also a student of math, if we plot energy versus time for a conflict, so the energy, it dissipates with time. It is inversely proportional to time. So the husband speaks, the wife speaks, and I did nothing. I was just mum. So keeping mum is also a soft skill. So I was just mum. What happened is the mother-in-law of that lady came with her child. The child was like 1.5, 2 years old. She was carrying that child in her arms. The moment they both saw the child, I just spoke one thing. आप लोग को शर्म नहीं आती इतने छोटे बच्चे के सामने इस तरह से बातें कर रहे हो? And the dispute was immediately resolved over there. They both, settled within themselves and they both hugged each other. I told them to hug each other and then go back, and that is how it was resolved. So we get as petty disputes as this, and soft skills like keeping mum can also play a role in mediation. So with this, I'd like to
I think
hand
this requires a round of applause, truly. And we need to come and get trained from you. Now may I also introduce Ms. Swati Gupta, who has a very interesting profile of political science, law and public service, great mix and a rich experience of 30 years in administration and public service as municipal councillor and zonal chairperson of East Delhi Municipal Corporation and Education Committee, but now as director of SBI. So, in all these roles, can you just, in your opening remarks, talk about the kind of conflicts you have faced now?
Thank you, and thanks for inviting me for such a very informative and highly discussion section. Let me tell you, conflicts and soft skills, both are two opposites. And me being in public for at least 10 or 20 years, I can understand the problem. You just mentioned I was a councillor from 12 to 17, and we are the public servants 24/7. So anybody can call us for any small petty issues as just a drainage system also. And we have to solve it in the night also, whether it is from birth till death. A councillor has to be very much, we have to be informative, and we have to deal with the public. But now, since I am dealing with the bank right now, SBI being the largest bank and the largest public sector bank with over 52 crores of at least customers. And we have more than 2 lakhs of our employees also and 22,000 branches. Just imagine the amount of people involved in this. And conflicts will arise and are arising. It is just as Mr. Singh was telling, it could be such a petty issue about the customer also. But let me tell you about the perspective of the branch manager who is handling at least 1 lakh of accounts. There's a pressure on him at that time when he is in the bank. It is so much that he cannot handle the pressure. Nowadays it is online, you can just have your own banking online. But the pressure of all people coming to the bank and just checking their passbooks and accounts, that itself creates a lot of pressure. And just as everybody is giving an example, I can also give an example of a 60-year-old man. He just comes every week, he just wants his passbook to be checked and to see how much is the balance left in this. ब्रांच मैनेजर ने उनसे कहा, सर आप हर हफ्ते क्यों आ जाते हैं यहाँ पर? आपको क्या मतलब, आप अपने घर पे बैठ के ही बैंकिंग करिए। बोलते हैं सर मैं तो रिटायर हो गया हूँ, मुझे तो कुछ काम नहीं है, मैं तो यहाँ पे आके बैठ जाता हूँ। तो the time of मतलब interaction with the public, and once his problem was not solved, he just lodged a complaint in customer grievance. We in the banking system, we have our own customer grievances where we can just tackle the issues of the customers. We have an internal ombudsman also and banking ombudsman from RBI also. But that is a long process. But soft skills from the manager at that time helped him not to lodge a case. If a case has been lodged, it would have taken a long time to be resolved. And by using a certain state of mind at that time, the branch manager helped it to solve. So these are the cases which comes there in the petty issues which can be solved very easily using the soft skills. And we have an HR department who gives proper training to all the branch managers at this time. But with a large number of people coming, I know the amount of pressure SBI has it right now. Thank you.
Thank you so much. And now may I turn to Ms. Sunit Kapoor, who is the Executive Director of Pension Fund Regulatory and Development Authority. With your rich experience of credit and risk management, capital markets and financial regulation, what is the kind of role that you're playing now with the bank, and even in your previous banking experience with Orient Bank, etc.? What kind of conflicts can you share with us?
So, good afternoon everyone. First of all, let me express my gratitude towards the E-Mediation for inviting me, especially to Ms. Push Gupta, who I've seen closely from a personal angle because I'm not in the legal field, but she's really devoted herself passionately and wholeheartedly, and she's living the dream of EMW. So kudos to her and her team to bring this EMW to this stage. As far as the soft skills are concerned, I think I'll take a different turn to this. Rather than talking about conflicts per se, what is the role of soft skill in a person's career growth? I think I'll take that aspect into account. So generally what I feel is, in a career progression, when you enter a workforce, it is your hard skills that matter. You should have the hard skills. They could be, computers, they could be medicine, any hard skills that you acquire through a degree, they matter at the entry level. However, if you have to go up the ladder, it's not just your IQ, it is also your DQ, how much hard work you put into it. That's also a skill. And as you rise even higher, it's your EQ and your SQ that matters. What is EQ? It's emotional quotient and the social quotient. How much social skill you have even in the work environment. That is very important as you go up the leadership road. Because, as a mother, I think you've seen that common meme in WhatsApp. It says, once you have one born child, you are a mother. But as soon as the second one comes along, you are a referee. So you become a referee from point one, so day one, the second child comes in. Because no two individuals are same, they are not clones of each other, they are not robots. They are individuals who are thinking, and they think in diverse ways. And hence conflict is a very natural thing to happen. So if there are more than one people involved, conflict is going to happen, it is bound to happen. And it is for the people who are in the leadership roles who have to navigate these conflicts, in a very smooth manner, so that it appears to be a win-win situation. Unless the leader is able to do that, I don't think they will be able to manage teams, they will not be able to achieve the goals, they will not be able to take the organization forward. So I think soft skills actually matter a lot for taking the organization forward.
Thank you very much. Now, may I welcome again Mr. Hon'ble. I've known him for many years. It's really refreshing to see you as the Joint Secretary of Delhi District Cricket Association, and in your previous avatar in real estate. I'm sure you also have faced a lot of chaos. Here it is more about team building, and there it is more about destructive, forces. So how can you share, the kind of roles that you are doing?
Thank you, team EMW, for inviting us and
can we reduce the noise?
Sorry,
Amit, can we reduce the noise in the hall? It's very disturbing right in here. If you don't mind, can you please reduce the noise in the hall, please? Please talk softly. Thank you so much.
Yeah, so thank you, team EMW, for inviting me here. I'm the Joint Secretary with DDCA, Delhi Cricket, and cricket being, India's heartbeat, it becomes very difficult for players, for coaches, for team management to not have conflicts. There are egos, huge egos, jealousy. You are working in a pressure cooker situation. As it is, you have a tremendously busy schedule. You have to win at all costs. That creates a lot of conflicts.
And it's very important. It's imperative for the team management, the coaches, even the players to have a good working relationship. Because if you don't, the team performance goes for a toss. Your morale of the team also goes for a toss. So it's very important. And the most important thing is to ensure that any conflicts are not leaked out. Because once it's leaked out, media is always looking for these kind of things, and it gets splashed on the newspapers. So it's very important to have a complete team having specialization in soft skills to ensure that any small conflict is also managed in a very time-bound manner, ensure that everything is set up correctly. So we have the code of conduct, we have ombudsman there, just to make sure that the parameters are there. But at the end of the day, it's all your EQ and SQ, like ma'am said, very, very important. The leadership, the management, the coaches, the players, they all have to work in coherence for that.
Thank you, Amit. Now, may I turn to Professor Nija Pandey for a scientific question, if I may. What is amygdala's role in, brain role, the amygdala part of the brain, in conflict management and to choose reacting versus responding? Okay. Yes,
Thank you so much for your question. I have a PhD in poetry, and I have been with IIM Lucknow for 26 years. When I joined, we had 6 IIMs, today we have 22. I established the first ever business communication department with a lot of persuasion and influencing to the then director that the most critical competence that every leader needs is communication. Because of the kind of things which these managers will have to do, with the competence which ma'am has talked about, because of conflict resolution and how they have to understand that where they have to, can they actually afford to react? You've used those 2 words, react and respond. So let me give you a little bit of a poetic answer to this question. I think my framework for any kind of handling of conflict resolution is the 3 M. First is that you have to engage your mind. We cannot be in an auto mode, whether we are a police officer or whether we are a professor, a mother, say bank officer, lawyer, doctors. The first thing is you have to engage your mind, and as soon as you engage your mind, so you are mindful now. You are mindful, and after that, you will have to appreciate the context, critical thinking skills. The more we train ourselves in the area where we are experts in, next is your matter. Now you will create your content, and then the delivery. So I think critical thinking skills of being skillful, because we have to skillfully manage, tactfully, like a mother, as she said, we have a kid or a 2, but grandparents, when they handled 16 grandchildren and each one of us believed that she loved me the most, what kind of tact and diplomacy was she using? Half-truths and maybe not such, not lies exactly. So I think, if you engage the mind, you are not reacting, you are responding. Because you've engaged the mind, you pause, you use your mind in that, and now you are mindful. I think at the moment what I see in a lot of meetings, board meetings and a lot of decision making which we see, all of us are running out of time. I think when we look at conflict resolution, I've had issues with the members of the committee that, like life and death, this is a question of pass and fail for a student. It's life and death for him or her. We have to engage our minds to the best of capability, and as my young friend said, we can only listen if we are not in a hurry.
Mind, matter, and management.
Mind, matter, and manner. How you say that. I think I have practiced this throughout my life. Small sensitive incidents. You have children now coming to the classroom who are just the only child. You give them feedback in front of everybody. You cannot do that. You cannot do that. As a faculty, I'll have to sit with this person. So you have to engage your mind. You cannot say that this is what was done to us. I think at the moment, empathy, sensitivity, listening, just listening, allow that catharsis to happen. And I think a lot of the conflicts I have been able to resolve as dean, as placement chair, where the biggest of conflicts come up.
Thank you.
Thank you so much for the question.
May I now welcome Dr. and Professor Bhalla, Sir Gangaram Hospital. He is a distinguished Indian nephrologist and kidney transplant surgeon. He is a co-chairperson of the Department of Nephrology in Sir Gangaram Hospital and a recipient, of course, of Padma Shri in 2010 and B.C. Roy National Award in 2019. So, welcome, sir. It's really a privilege to have you over here. May I request you to just share with us the role of mediators and trainers to build bridges between doctors and patients, especially when it comes to medical negligence and such issues that you might be facing on a daily basis.
Thank you for inviting me for this very, very unique panel discussion. I will start from the training of MBBS. During our curriculum, we are taught of all the theory, physics, anatomy, physiology, biochemistry, medicine, but nowhere it is taught the etiquettes and the way you should talk to patients. By the time you pass your MBBS, you actually are totally negligent, zero, as far as this aspect is concerned. The empathy part is not taught at all. And that is where you were saying the role of a trainer or a counselor is there. Now, after MBBS, which is so basic education, then you go to MD or MS and postgraduate studies. Again, nowhere it is only the academics, theory, and then practical. In practical also, it is all totally stepwise, stereotype, question answer sessions, make the diagnosis, what will you do the treatment, that's all. Nowhere you are assessed that how to talk to patients. That is where actually, due to the lack of this factor, you are doctor is now coming to the society. You are producing a blood which goes to the society, knows everything about the subject, but the most important thing, how to deal with the patient, that part is never taught, and that part is, there is no counseling at any time during the training. There is no trainer or counselor available in medical colleges. So that part is lacking. Now to have a good doctor to practice his profession, you have to have that A, B, C, D standards. A is of course availability. Whenever there is a problem, doctor has to be available because it is a concerning your life. And B is your behavior with the patient. Again, that also has to be inbuilt or you have to work it. And C is most important is how to communicate with the patient. So that communication is very, very important. That part, I think there is a role of a proper counseling sessions when these doctors go into the society. And then competence also is there. That C means competence. Doctors should be competent. And next is D. D is today the most important thing as far as medical cases, legal courts, and going to courts, and from police complaints,
the documentation. So that is what I will see, that A, B, C, D of medical profession, which every doctor should take it seriously. Now, when there was no consumer law covering the doctors, there was no problem. Patients, the public used to treat us as God. Today also patients are saying, Doctor Sahab, aap to Bhagwan hai. So that feeling in our country is still there. 90% of the patients feel that doctor is actually next to God. Every day patients tell us that doctor is next to God. But now, since that we are covered under consumer law, so there is a national consumer law, like other professions, doctors are also coming under that profession. So now it has been made as a commodity. So doctor is now you treat the patient as a customer, which was never so. And now you are selling your talent, you are selling your expertise, and doctor is paying for that expertise, and that's all. So doctor feels that I have given a fee of 500 or 1000 rupees, and that's all. So that patient and doctor trust is lacking day by day. And one of the factor which is precipitated in this is today the Google. You have a Google search engine, you can get any information much more than the doctor on fingertips. Now you put your disease on chat GPT. You will get beautiful answer which even best of the doctor cannot answer. Now you have the artificial intelligence. So with that artificial intelligence, on that medical topic, there will be more than lakhs of references and studies which have been fed into this chat GPT or AI. From that AI, you will get the treatment which even a best of the most intelligent doctor will not be able to write. Similarly, if we put a chest X-ray, AI will make a diagnosis which ordinary radiologists cannot make. If histopathology report is put in, AI doctor will give the report which is most likely accurate. So, this is a new challenge we are facing now. Now, once the patient, this lack of trust, and patient goes into the consumer court, patient goes for a police complaint, so then there is a role of mediation. So how this mediation, how this EMW, what is the role of this? So that's why every hospital should have this mediation cell. So that if a patient is dissatisfied and if someone is there who can call both the parties, and then he can sort of listen to the grievances, and maybe that 90% of the problem will be you will be able to solve. So that's why I said so far there is no such mediation cell. You have arbitration in the legal, you have this, but for medical negligence you do not have any mediation cell. So I think this is a very good idea that you have involved a doctor also in this panel discussion, and I think there is a definite role for this mediation.
Thank you, sir. So in fact, strangely in our own profession, in dispute resolution also, we are not trained how to communicate. You know, so even as lawyers and judges, the clients have to face our egos and the way we talk to them, and when as mediators we have to retrain ourselves how to communicate to them, how to empathize with them, how to wear a different hat. So I think our education system is such that it doesn't teach to see the needs of others, to understand the feelings of others, and then to give our advice only when required. So thank you so much. I think you've hit it on the nail, and yes, there is a lot of room for such thoughtful change. So may I now just ask Amit Grover, who also faces a lot of egos and young and old teens, that what kind of training would a social training would a sports association be open to?
So that's a good question. Even the players have the talent, they have the discipline,
but just to manage their egos is always a huge task. As an association, what we do is we keep a clear and open communication channel, which is very important. Just have an active listening mode with them, just to understand, because they see these players, they come from very different cultural backgrounds, very diverse. They don't even, they sometimes language barriers also there. So a lot of these issues have to be handled with a very delicate understanding. So a huge amount of empathy is required. You have to be very empathetic to each and every player. So what we do here is we have now that cricket's become quite big, we have specialists who handle a lot of these situations. But at the same time, what we do require, is something for the three mediation training programs are very, very important for each and every person who's part of the ecosystem. Very, very important for them to, have a clear understanding of what needs to be done. And this is where I think EMW can be a great help for
Thank you, thank you. Now, as a concluding round, may I ask Sumit, in one word, which is the topmost soft skill that you can think in one word?
I think communication and empathy. These are the two
Thank
words
you.
which should be.
Thank you. Dr. Balla, any second thought of one word? Top skill?
I think empathy is the most important thing. Doctor, whether you are a doctor, whether you think yourself in that, and then you practice.
Thank you. Swati, can I ask you for one word? Soft skill that comes to your mind.
Soft skills should be always emotional. That I think because without emotions you cannot communicate with the person whom you are interacting with. So that is emotions.
Thank you. May I request you to give your one top skill?
I cannot think of that one word, but then I'd like to say that understanding the people having the conflict is important than understanding the conflict itself. Because if you understand the people, conflict may be of a different nature. One kind of conflict can have different kind of people having that conflict. So if you understand them, what kind of dispute they have and what is their outlook towards the conflict, it's easier to solve it.
Understanding is your top skill. May I request Professor Neetu?
These days, we are using a lot of storytelling for changing mindsets. And we find that it's really working very well. Just 2 days back, we had 50 senior leaders, and I had a filmmaker who's actually a storyteller, and we just gave them one assignment, that change your narrative. Go back, a friend with whom you've not talked for 20 years, but you really want to, go and talk to him. And they all loved the exercise, so storytelling is coming out as a very, very important soft skill.
Interesting. Mandeep, what about
I feel it's active listening. Because while commuting also, one has to be patiently and actively listening to others. And at present, we all feel that everybody is talking, but there is no ears. So that is very important to give to somebody like me.
Thank you so much. We have a galaxy of panelists from different sectors, and we couldn't have got better panel than this. Spanning so many sectors. So now the time has come. All good things must come to an end, but lunch is also waiting. So may I now request Prerna and Prema, Priyadarshini and Sapna Sinha to present the scroll of honor to Mr. Sunil Kumar Jha. And he truly has the heart of a police. Now may I request Vinita Sahai and Dr. Deepika Saini to present the scroll of honor to Professor A.K. Balla. Deepika? Deepika Saini, where are you? May I request Sarika Jetli and Ajay Jain to come and give a scroll of honor to Mr. Sumit Kapoor. May I request Sanjay Sharma and Seema Gulati come on stage to give a scroll of honor to Professor Neerja Pandey. Beena Nasyal and Ekta Thakur, please come on stage to give a scroll of honor to Amit Grover. Ginny and Arunima, please come on stage to give a scroll of honor, Ms. Mandeep Kaur. Jaya Tomar, Usha D from Pondicherry and Shubhra Parashar, please come on stage to give a scroll of honor to Ms. Swati Gupta. Now may we have a photo for the panel? A photo for the panel, this will remain a great memory. And please do wait for lunch. Everybody is requested to wait for lunch. I know you all have waited for longer than the, but I request the panelists to wait for lunch. Sanya, may I
invite you for the next one. Malhotra.
Ladies and gentlemen, esteemed guests, distinguished judges, and dear participants, good afternoon to you all. I request everybody to kindly settle down for the valedictory session.
Everyone to be seated, please. Everyone to be seated. Please. Please be seated. Our honorable guest, Honorable Justice Taylor Scully is here. Please be seated and let us not have so much of noise. That corner there, please be seated.
Please be seated. I request everybody to be kindly seated so that we can begin with the valedictory session. I know we all are waiting for the lunch. Ladies and gentlemen, esteemed guests, distinguished judges, and my dear participants, good afternoon to you all. It is with great pleasure, great honor, and immense pleasure that I stand before you today at the conclusion of this enriching National Mediation Conference on Outreach of Mediation 2.0, exploring new pathways. Throughout this conference today, we had the opportunity to participate in two enriching discussions on empowering society through mediation, a bar and bench perspective, and the unspoken solutions, soft skills for real conflict, that delved into inspiring discussions, insightful sessions, and valuable exchanges that have undoubtedly contributed to the advancement of mediation practices and the promotion of peaceful dispute resolution. To commence this valedictory ceremony, I am delighted to invite and warmly welcome our esteemed dignitaries who have graciously honored us with their presence today. Please join me in welcoming Honorable Mr. Justice Rajendra Menon, former Judge of the High Court of Delhi and Chairperson Armed Forces Tribunal Principal Bench and the Patron-in-Chief of E-Mediation Writings, and Honorable Mr. Justice Tejas Karya, Judge, High Court of Delhi. Sir, your presence today has been truly motivating and has added immense value to our gathering. As a gesture of our appreciation and respect, I now invite Ms. Kajal Chandra, Advocate Delhi High Court, and Mr. Nishant, Advocate Delhi High Court, to present a small plant to our distinguished guests, symbolizing growth, stability, and the nurturing of justice, values that resonate deeply with the spirit of mediation. Justice Rajendra Menon, our patron-in-chief during the first Judges Conclave on Mediation Education, organized by E-Mediation Writings in 2021, expressed that while mediation has explored in litigation and even at the pre-litigation stage, there remains a significant need to organize and introduce it across other organizations as well. Today, with the successful convening of this National Mediation Conference, we are proud to have taken a substantial step towards that goal, sir. Sir, we could not have achieved this without your unwavering support and steadfast patronage. It is with great honor that I now invite you to address the gathering, as your insight and guidance will undoubtedly inspire us all as we continue to promote mediation and peaceful dispute resolution.
Good afternoon to each and everyone. My esteemed brother Kalwa from Delhi High Court, Justice Shri Jain, Mr. Chetan Sharma, Mr. Lalit Bhati, all the other dignitaries, guests who have come from all the places throughout the country, from Kanyakumari to Srinagar. At the very outset, I would express my deep felt regrets, apology and sorry for not having come in the morning, even though I was shown as a speaker to welcome all of you in the morning and the other guests who had come, but on account of some pressing official engagement that had come, and you can imagine if Push could excuse me to come in the morning, what was the pressing engagement. Otherwise, Push is one person who would never permit you to leave even for a minute. Most of you here have come, I know, leaving very important engagement only because Push wanted you here and you have all come here. So that is the leadership which Push has shown to us, and my association with EMW started during the COVID period when Push and Meena Khare wanted me to be part of this organization to start a electronic magazine on e-mediation, and I, in my capacity as the elder brother to both of them, gave my willingness to be part of this, and it's been now 5 years since I have been associated with them. As I always say, I don't know anything about mediation. I am not a trained mediator. I have not done mediation, but I have been part of the administration of mediation in the judicial system right from 2008 until now. And mediation has taken to my heart, and I feel that mediation is one of the best mode of redressal of grievance in the litigation system. And I can say that he is nothing less than a guru and guide to me as far as mediation is concerned, and he is sitting here, Justice Sudhir Jain. It was the inspiration given by him, the courage which I got from each one of you, traveling for EMW. Manjeera took us to Hyderabad. We had gone to other places also with regard to e-mediation conferences and seminars, that I took the courage to talk to the then Chief of the Defence Staff, Lieutenant General Bipin Rawat, and got permission from him to introduce mediation into the Indian military. I don't say army, I say Indian military. And it was with the help of Justice Sudhir Jain that we could introduce mediation into the Indian military, and with the help of Mr. Sudhir Jain and most of the mediators who are present here, Meena Khare, Pushp Gupta and so many others, that we undertook 3 sessions of 40 hours mediation training to 120 officers of the Army, Navy and Air Force from the rank of Major to Brigadier. And today, mediation is part of the system in the Army, Navy and the Air Force also. And as I always say, and most of you might have heard, when I talk to the officers in the armed forces as to how mediation has helped you, they always say that, sir, it has changed the complexion of life. It has changed the way we deal with our subordinates. One of the commandant told me, कि सर, जब मीडिएशन के पहले कोई सोल्जर या सिपाही मेरे पास आता था और कहता था छुट्टी दीजिए, गांव में जाना है, तायुष से कोई छुट्टी नहीं, जाओ एंड आज काम करो. But after mediation, when they come to me, I tell them, बैठो, बताओ कि क्यों जाना है, and after I hear them, I give them a leave and ask them to go home. So that is how my relationship with my subordinates and the way of dealing with them has changed, and that has brought a lot of difference. Dear friends, I am part of each one of you. Whenever you need my help or guidance, I am always available. You started the session at 9:30. It's already around 3 o'clock. Lunch is waiting for you, and I don't want to convert this into a technical session and deprive you of your rightful claim for lunch this afternoon. Thank you very much. Jai Hind, Jai Bharat.
Thank you, sir. Your words, your inspiring words and encouragement has brought us to where we are today. Thank you so much. Our special guest for the valedictory session, Honorable Mr. Justice Tejas Karia, has been an ardent supporter of alternate dispute redressal mechanism, extending his advocacy not only within the legal field but beyond it as well. Throughout his distinguished career, he has championed the inclusion of area practices across all spheres of life, particularly in business and commercial transactions. We sincerely thank you, sir, for graciously accepting our invitation and for your continued support and commitment to promoting the principles of mediation and alternate dispute resolution. I am delighted to invite you, sir. Please share your thoughts with us on the perspectives on mediation.
Justice Menon, Dr. Justice Sudhir Kumar Jain, Mr. Chetan Sharma, Dr. Lalit Bhasin, and dignitaries present today, ladies and gentlemen, good afternoon to all. I am very happy to be here on such a great event which is organized by EMW. Mediation, as we all know, and we all have experienced, because I see the room is full of experienced mediators, is an integral part of justice delivery system. Today, what we are facing in the justice dispensation is that there is a lot of delay, there is a backlog, there is a frustration within the users to get the justice at the earliest, at the most cost-effective manner. We have found arbitration as one of the tools as an alternative dispute resolution to resolve the dispute in a commercial matter. But there are certain limitations with the arbitration, because arbitration is, at the end of the day, is adjudicatory function, whether one party wins and the other party loses. And there is no real finality, as we have seen in our experience with the arbitration, that we have to go to court for setting aside. There is a jurisprudence with regard to the power of court to set aside the award, and there is an appeal, and then there is a SLP before the Supreme Court. But mediation, it has a unique characteristic. What is not really arbitrable can also be mediated. There is no requirement to be experienced under the process of a legally trained mind to become a mediator. I was doing a training, a diploma course in training, and I found that the participants were from all walks of life. There were air hostesses, there were doctors, engineers, and we have seen in this room also. It's a very diverse culture of and the fraternity which we have of the mediators. What we need is training and a change of mindset. And the moment we have that kind of a training, professionalism, what we do to mediation, we should treat them as the main profession because it's no longer an alternative. It is an integral part of our dispute resolution mechanism because what mediation can offer, starting from pre-litigation mediation, we have a community mediation, we have the Mediation Act now, which really encompasses all the aspects of mediation. It will have a Mediation Council of India, there will be accreditation of the mediators and the mediation service providers, which will bring the institutionalization into the field of mediation. With all that changes, we have an advantage in India with the kind of diverse culture and background we have. We heard the previous panel where the kind of experience and expertise we have in our stakeholders is unparalleled. No other jurisdiction in the world has this kind of experience and expertise in the common law background. We have the experience in handling the disputes, and we can make mediation a great avenue for resolving the dispute. And by doing that, what we will achieve is reduce the time, reduce the backlog in the court system. And there are so many virtues in the field of mediation that we can't even imagine unless we experience. The only problem I see is lack of formal training. We see 40-hour training being given by various institutions, but we need to standardize that training. We also should have a training for online mediation, which is the same, but it has slight nuanced approach towards the mediation, and it has its own benefits. With regard to the online mediation, is that you can save time and cost in traveling and finding time between the parties who can come together and resolve the dispute. What we need to also do is pay the mediator as if we are paying the arbitrator. Because by doing mediation, if we do the analysis, we are saving a huge cost because there is no further appeal, it's a finality which we achieve, and we reduce the cost of litigation and the time for getting the resolution of the dispute. So we need to have the fee schedule for the mediators, which should be based on the percentage of the amount in dispute and not the time we spend. Because if you spend less time, you should be rewarded more rather than getting paid less. So that is something we need to bring about in mediation. And I'm sure with the initiative which we are taking and the law which we have now for last 2 years, we are going to make mediation a great success in India. I know I'm the last person in between you and the lunch, so I'll not take much time. But something which I have really learned in recent past is since I've become a judge, I have to listen more than speak. Earlier I was a counsel and I was speaking more and judges were listening. And something which strikes me is as a mediator, you have to listen rather than hearing. And once you start listening, you are able to understand not only the legal aspect, the reason for the dispute. You have to go to the root of the dispute and you can find the solution. So active listening, I heard the panel saying there are a lot of empathy and other aspects are there, but listening in mediation is a great art. And moment we start listening, not the mediator but each other, then we will be able to resolve this. With that thought, I thank all organizers, especially Ms. Push for inviting me, and wish you all the best. Thank you.
Thank you, sir, for your valuable insights and support. We hope we will be able to fulfill as we discussed. Now, I would also like to welcome our distinguished guest, Honorable Mr. Harsh Malhotra, sir. Thank you, sir, for taking out time for our busy schedule and joining us today. Our Dr. Shri Harsh Malhotra is the Union Minister of State, Ministry of Corporate Affairs, Union Minister of State, Ministry of Road, Transport and Highways, Government of India. Sir, we welcome you today. I request Ms. Rajendra Menon and Mr. Yugveer Singh Chauhan, sir, to come and please give the flower. Now, I would like to invite Mr. Malhotra sir to kindly come and share a few words of thought. Thank you.
बहुत बहुत धन्यवाद। आज दिल्ली में जो बीजेपी के लोग हैं, नेता हैं या चुने हुए प्रतिनिधि हैं, संगठन के लोग हैं, उनके लिए बहुत हैपनिंग सुबह से है लगातार। मुझे सुबह मैंने कुछ को बोला था कि मैं 10 साढ़े 10 बजे आऊँगा जब आप शुरू करेंगे, पर आज 3 इवेंट्स करने के बाद यहाँ आ रहा हूँ। मुझे ये पता नहीं है मुझे यहाँ क्या बोलना है, लेकिन माइक में बिठा दिया है तो कुछ ना कुछ बात करूँगा। मंच पर रिस्पेक्टेड जस्टिस राजेंद्र मेनन जी, जस्टिस तेजस कारिया जी, जस्टिस सुधीर जी, मिस्टर ललित भसीन, हमारे एएसजी साहब चेतन शर्मा जी, उनका नाम बहुत सुना है, आज मिल दूंगा ठीक से, राजेश मिश्रा जी, सेक्रेटरी बार काउंसिल ऑफ दिल्ली, पुष्प, और यहाँ पर उपस्थित सभी दोस्तों, मातृशक्ति। जितना मैं पुष्प से बात करके उनका इशू समझ पाया तो मुझे लगा ये सबसे मुश्किल काम है मीडिएशन, और उस पर इन्होंने 2 बुकलेट्स भी आज रिलीज किए हैं। और उस समय शुरू किया है काम जब कोविड था, और कोविड के टाइम में कोविड ने एक अच्छी बात सिखाई कि हम डिस्टेंटली भी बहुत कुछ कर सकते हैं। कोविड में कुछ भी अच्छा नहीं था, लेकिन ई-मीटिंग्स और ई-कॉन्फ्रेंसेस ने कोविड के कारण से हम सब लोगों को काम ज्यादा करने की आदत भी डाल दी है। अब तो तब से कोर्ट्स भी इलेक्ट्रॉनिकली लग रही थी, हाइब्रिड कोर्ट्स भी लग रही थी, पर मीडिएशन और मीडिएशन में भी जो लोग मीडिएट करेंगे उन लोगों को गाइड करना ये बहुत महत्वपूर्ण लगा। ये है भी डेफिनेटली, वो कुछ ना कुछ लीगल बैकग्राउंड के हैं या कुछ साइकोलॉजिकल बैकग्राउंड के हो सकते हैं, लिटरेरी पर्सन हो सकते हैं, लेकिन उनको भी गाइड करना। और सबसे पहली बात कि मीडिएशन में जो प्रिवेंटिव मेजर्स हैं उसके माध्यम से भी, अब हमारा परिवार ही है, परिवार में हस्बैंड वाइफ है, बाप बेटा है, अब बच्चे यंग हो जाते हैं तो उनका माइंडसेट चेंज हो जाता है, जनरेशन चेंज हो जाती है। अब चाहे पिताजी कितने ही बड़े आदमी हो, चाहे वो जस्टिस हो या एडवोकेट हो, मेरे फादर भी सीनियर एडवोकेट रहे, इसलिए मैं उस चीज को समझ पाता हूँ कि वो हमें प्रिंसिपल भी थे, वो समझाते थे कुछ कि ऐसे करना है, तो हमें कभी कभी लगता था कि ये ओल्ड स्कूल ऑफ थॉट है, मैं तो बिल्कुल ठीक सोचता हूँ, जबकि मुझे अब लगता है कि मैं गलत सोचता था। इसलिए कह रहा हूँ कि जो मेरे आगे आने वाले बच्चे भी इस बात को ठीक समझ लें कि मैं उस समय गलत सोच रहा था जब मैं यंगस्टर था। पर मीडिएटर्स को भी ट्रेन करना और उन ट्रेनिंग में उसको प्रिवेंटिव मेजर्स की तरफ ध्यान देना, ये वाकई बहुत महत्वपूर्ण है। उसके लिए उनकी इंटरपर्सनल स्किल्स उसको डेवलप करना, और जहां पर ऐसा लगता है कि कोई डिस्प्यूट सिर्फ इंटरपर्सनल स्किल्स को डेवलप करने से प्रिवेंट किया जा सकता है, ये अपने आप में एक डिफरेंट फील्ड है, बड़ा काम है। आज कोर्ट्स में बहुत लंबी लाइन लगी हुई है लिटिगेशंस की, और इतना लीगल सिस्टम को डेवलप कर लेने के बाद भी एक टाइम था जब 15 साल लग जाते थे, ऐसा कहा जाता था 20 साल लगते हैं, लेकिन आज वो टाइम पीरियड बहुत कम हुआ है, इसमें कोई दो राय नहीं है। लेकिन उसके बावजूद जो ये मीडिएशन है या आर्बिट्रेशन भी उसका एक पार्ट है। कई बार आर्बिट्रेशन से भी बहुत से मामले सुलझ जाते हैं। मैं जिस मिनिस्ट्री में हूँ, रोड ट्रांसपोर्ट में, उसमें हमने अपने आर्बिट्रेशन के लिए भी अलग से एक डिपार्टमेंट बनाया है, ताकि बहुत से मैटर्स आउट ऑफ द कोर्ट अगर हम रिजॉल्व कर लेते हैं तो वो बेटर रिजॉल्व होते हैं, और वो इस लेवल पे भी रिजॉल्व होते हैं कि आफ्टर द रिजोल्यूशन आपस में एक दूसरे के संबंध भी कम से कम टॉकिंग टर्म्स तो रह जाते हैं। कई बार ऐसी स्थिति भी रहती है कि आफ्टर डिसीजन ऑफ द कोर्ट टॉकिंग टर्म्स भी नहीं रहते हैं। तो आर्बिट्रेशन और मीडिएशन एक अच्छा मीडियम है, और इसके साथ साथ पुष्प जी और उनकी टीम, मुझे देखकर बहुत अच्छा लगा। पुष्प जी से जब बात हुई तो उन्होंने बताया कि पैन इंडिया इस काम को कर रही हैं, और पैन इंडिया उन्होंने अपनी टीम डेवलप की है। मेरे को अभी असम से आए हुए साहब मिले, तो ये अपने आप में एक बड़ी बात है और ये बड़ा इनिशिएटिव है। मेरे को लगता है कि जब इन्होंने शुरू किया होगा तब इन्होंने नहीं सोचा होगा कि वो इस लेवल तक पहुंच जाएंगे, और जिन्होंने स्टार्टिंग में उनके बारे में इस इशू को लेकर के बात की होगी तो लगता होगा ठीक है, दिल्ली में रहती है, दिल्ली में कर लेंगे, लेकिन उसको पैन इंडिया लेकर के जाना, इस बात के लिए मैं पुष्प जी और उनकी टीम को बहुत बहुत बधाई देता हूं। और मुझे ऐसा लग रहा है कि भोजन का टाइम भी हो गया है, ज्यादा कुछ ना बोलते हुए आप सब यहाँ पर आए हैं, आप सबको बहुत बहुत धन्यवाद। भारत माता की।
Thank you, sir. I would also like to take this opportunity to acknowledge and extend my sincere gratitude to the EMW team, including the senior members, for their unwavering dedication to the cause of mediation. Additionally, I commend our young envoys for their hard work and commitment in organizing this conference today. Your collective efforts have truly made a meaningful difference. Now I invite Honorable Mr. Justice Rajendra Menon sir, Honorable Mr. Justice Tejas Kataria sir, and Shri Malhotra sir to kindly present the appreciation awards to our esteemed senior members and the young envoys of EMW as a token of recognition and their valuable contribution. I request our senior members to come forward one by one. I would begin with Mr. Thankanchan VP, Mr. Yudhveer Singh Chauhan, Mr. Rajesh Kumar Bhadra to kindly come on stage. I would now like to invite Ms. Meena Khare, Ms. Devjani Mitra, Ms. Suresh PG to come on stage. Ms. Rita Bhandari, Ms. Manjira Venkatesh, and Ms. Sandhya Kohli. Mr. Sachin Jain, Ms. Promila Acharya, Ms. Promila Acharya, Ms. V. Usha Shemala, Ms. Namita Chaudhary, Ms. Praveena Gautam, Ms. Pooja Anand, Ms. Anchal Tandon, Ms. Vinasha Soni, Ms. Archana Malik, Ms. Ruchi Khurana, Ms. Reema Kalra, Mr. George Malhotra, Ms. Lata Prasad, Ms. Kamalakshi Singh, Ms. Anupam Sanghi, Mr. Hari Krishna Ramseva, Ms. Saroj, Ms. Pooja Sharma, Mr. Tarun Namgia, Dr. Deepika Saini, and Mr. Anil Bakshi. Moving on to our young involved. Mr. Anil Bakshi. Uncle, sir, we request you to Anil Bakshi sir is here. Anil Bakshi sir is here. Moving on to our Suresh sir. I would request Aditi Tyagi, Chandrika Gupta, Garima Satdev, Gunjan Bansal Anand, Neenal Duggal, Manya Gupta, Neenal Duggal, Nihar Baijal, Rishpreet Singh, Rohan Chatterjee, Shifali Chaudhary, Shri Chaudhary, Rishpreet Singh, Rohan Chatterjee, Shifali Chaudhary, Shri Chaudhary, Soumya Tyagi, Khushbu Mittal,
Last but not the least, I would request Sania Bhatia and Akanksha Chandu. Manya Khanna, okay, Arnav Tandon, अमूल्य गुप्ता, जानवी शर्मा, कीर्ति मदान, मधुमित कपूर, मोनिका त्यागी, ऋतु भारद्वाज, सिद्धार्थ त्यागी, शुभांकर रे, विधि गुप्ता, शुभांकर रे, Miss Gayatri Puri, Miss Priya Indrani. Thank you so much, sir. Please have a seat. Finally, I request Miss Anchal Tandon and Miss Vinasha Soni to come forward and bestow our scroll of honor to Honorable Mr. Justice Rajendra Menon, sir. And we would like to also invite our Coordinator-in-Chief, Ms. Pushp Gupta and Mr. Dhankandal, sir, Senior Founding Member, EMW, to come and present the scroll of honor to Mr. Malhotra, sir. I would also like to request Ms. Neena Khare to come on stage. Thank you, sir. Sir, I request you to I would request everyone to come for the group photograph. Starting from Dr. Subir Kumar Jain, sir, Lalit, sir, please come, Rajesh Batra, sir, please come. Chairperson Sharma, sir, please. Nagina Jain, ma'am, please come. Anupam, ma'am, please come. I request all our members, all present here to come forward for the group photograph.
लाइव चल आपको सीधा
I think
ये लगाया कैसे उस मैडम को देखो उस वाली मैडम को मैडम लगा
I request everybody to now proceed for lunch. Thank you. Finally.
सर मैं लाइव पे किस
एक ले लो
ये लाइव दिखा रहा है उसके लिए नहीं सिर्फ लाइव
we have an office there. Mostly my area is this sports, entertainment, copyright. I am here for last 30 years. But you have asked where?